So good morning, everyone, and welcome to today's work session in the Joint Standing Committee on Health and Human Services. We'll be hearing 7 bills this morning, working 7 bills. Yep. And then we'll go to a public hearing when we conclude those and after some lunch and maybe a break or two. So we won't be taking testimony in the formal format, but we will be looking at the attendee list to see if you might have something that would help us advance the work on a given bill. So if that's the case, I invite you to put your hand up, and it's at the discretion of the chairs to move you over into the panelist role. So for right now, we'll do it that way. Everything is recorded as it has been all session, and you can go back and look at anything you missed by going to the YouTube channel. You find that by going to the legislative website, looking for the Health and Human Services Committee on a drop-down, and then going to the YouTube link, which is there. So why don't we proceed to introduce ourselves as the committee, and we'll start with Representative Zager.
Good morning. Thank you so much, Mr. Chair. I'm Sam Zager. I represent District 41 in Portland.
Representative Lemelin.
Thank you, Senator. Good morning, everyone. My name is Michael Lemelin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Nobleboro.
Representative Perry.
Good morning. I'm Ann Perry. I represent House District 140, which includes the communities of Indian Township, Baileyville, Barron, Callis, Charlotte, Robbinston, Perry, Pembroke, and Pleasant Point.
Representative Connor.
Thank you, Mr. Chair. Good morning, everyone. My name is John Connor, and I represent the good folks of part of Lewiston.
Representative Stover. Your turn, Representative Stover. Yep, we could hear you for a minute.
Oh,
now we're good.
Good morning. My name is Holly Stover. I represent House District 89, including the towns of Boothbay Harbor, Southport, Edgecombe, Westport Island, and South Bristol. Thank you.
Thank you. Representative Madigan.
Thank you, Mr. Chair. Good morning. My name is Colleen Madigan. I represent House District 110, which is part of Waterville and part of Oakland.
Representative Craven with your flowers.
Thank you, Mr. Chair. Good morning. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
Representative Jabner.
Good morning. I am Representative Kathy Jabner. I represent House District 141, which is located in Penobscot and Washington counties.
Thank you. Senator Moore.
Good morning. I'm Marianne Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer.
Thank you, Mr. Chair. I am Representative Michelle Meyer, proudly serving Southern Maine's District 2, which is all of Elliott, where I live, and parts of Kittery and South Berwick.
And I'm Ned Claxton, and honored to represent the folks in Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. We're joined today by the staff who makes this all possible and who have been working very hard in the last weeks to get us to this point. And I'd invite Anna Broom to introduce herself.
Hi, I'm Anna Broom. I'm one of the 2 legislative analysts for this committee, and I work in the Nonpartisan Office of Policy and Legal Analysis.
And Karen Thomas.
And I'm Karen Thomas, happy to be the clerk for the Health and Human Services Committee. Should you need assistance, please email me at hhs@legislature.maine.gov.
So we'll be hearing the bills we need to work on today, or in the following order. We'll begin with LD 393 and then go to 1824, 1850, 1853, 1834, 1825, and 1866. As I said, there'll be a break, at least one in there somewhere probably, and some lunch before we get to the public hearing. Anything else to touch base on before we begin, Anna? Okay, so let's begin with a conversation about LD 393.
Hopefully you are looking at 393.
We
There.
are.
Okay, good. All right, so this bill was originally a concept draft, and you have received a couple of times the amendment to replace the concept. So I'm going to talk mostly about what the bill does. So it provides $1 million in each year for additional services under the Home Builders Program. It provides $1 million each year for additional services under the Parents as Teachers Program, which is operated through the Home Visiting Program. It provides $420,000 in each year to increase the contract for kinship navigators. It requires the Department of Health and Human Services to study the ability of the state to allow a parent of a minor child removed from the home, but still engaged in reunification activities, to continue receiving whatever services they were receiving prior to their child being removed from the home, as well as receiving priority for waitlisted services that are necessary for transitioning out of the child protective system. And that includes things like transportation, childcare, housing assistance, home visiting, housing vouchers, and behavioral health services. Some of those are in the former category of services you were receiving before, and some of them are in the waitlisted category. And then the department would submit a report to this committee no later than February 1st of 2023. It provides $200,000 in each year in the Child Protective Services Contingency Fund, which is a fund that allows for sort of short-term use for unexpected costs. And it would also include a summary of the uses of the contingency fund into the annual report that the department gives you on child welfare that comes to this committee. It provides funding for one full-time person in the department in the Commissioner's office to coordinate the organization of the child welfare system across state departments. And there's some new language for that I will get to in a moment. It requires the Recovery Fund Council that you heard a lot about with 1722 and the opioid settlement, established in the Memorandum of Understanding regarding the use of opioid settlement funds to expedite the resources to expand medication-assisted treatment in rural areas of the state and through FQHCs to ensure that families involved in the child protective system are able to access treatment. And it also requires the council to expedite the development of peer recovery centres in every county in the state. So you heard from the sponsor, co-sponsors, and proponents that these proposals are focused on strengthening and stabilizing families to prevent abuse and neglect and to reduce the need for child protective intervention. You heard from the folks that have the contract for kinship about the number of referrals that they have, because this was there's a piece of that in this bill. And they have a staff of 4 currently serving an average of 70 new families every month. You heard from the Maine Children's Trust, who have the responsibility for the home visiting program, and is also the home to the Parents as Teachers State Office. And this year, Maine Families is about to enroll families referred for prevention services that have open cases with the Child Protective System. And they did point out that Parents as Teachers is not a behavioural health program, and I'll get to why that came up in a moment. And then you heard from the MCA about the precedent for a leadership position within DHHS to oversee child welfare services during periods of reform. From 1999 to 2011, there was a director of special projects who worked for the commissioner, and then the director of OCFS to support the design and implementation of the previous child welfare strategic reform plan. And they are also asking for considering waivers to keep the basic needs. That's back to the services received before the child is removed. So the issue of behavioral health, that's my mistake, but it's a mistake that doesn't have an actual consequence. What I mean by that is the way that that amendment is drafted is really, it has headers in it that are just there to help orient you. But when an actual amendment goes to the reviser's office and the fiscal office, those headers would not be there. So yes, I got the header wrong, but the good news is the header doesn't matter. When it gets sent out, it would just be the initiatives would show up, the initiative for the $1 million, the initiative for the $1 million for the next one. So I appreciate that because that's just a lack of knowledge on my part. So I did get the header wrong, but it doesn't actually matter. The header for the funding initiatives for home builders and parents as teachers, the funding initiative language, I believe, is correct. It's just that the header is wrong. And then you also have some replacement language from the sponsor, who is Representative Meyer, for the department coordinator initiative, which is section, sorry, let me just find out what section of the bill it is. It is, oh, it's under number, it's the one that says, I guess I don't have sections, but there is a section 3 in there of the language, and this is the language that they're proposing to change. And you can see there a longer description of what that would look like. I am quite certain you don't want me to read it out, although I'm certainly happy to do it. And then but you also have the folks here who have proposed that language along with the sponsor. So you did have a question about the home visiting program. And so I did reach out to Pamela Hay about that. There is a wait list in Southern Maine at the moment. There is a list of 63 families, but they are also operating at 90% capacity because they also have vacancies and workforce challenges. And she did sort of clarify for me, because I was a little confused about how it all fits together, that Maine Families is the name of the state's home visiting program, and the Maine Families uses parents as teachers as its evidence-based model. And then this could have come up for any of these bills. It's just actually kind of fortuitous that I put it on the bottom of LD 393 because I didn't actually know which one we'd be doing first. A couple of committee members had some questions about any information available about the history of child protective reforms and also gaps in the service. I sent those questions to the department and also to Maine Children's Alliance. You can see that I got some information there from the Maine Children's Alliance. I am personally not equipped to answer these questions about the history or the gaps in the system. And there's a couple of reasons for that. One is just that I wasn't here, but the other, I think, is that there's also, in addition to there being a lot of changes, I think the landscape has changed. So, you know, things like the opioid issue wasn't an issue last time you had a round of these things. So I'm not equipped to answer that. And even if I was, I think there's an element of a sort of a lens that you are looking through. And we in OPLA as nonpartisan employees don't do that. So you do have some, I did send those questions out knowing that they were kind of tricky and big questions. It's up to you where you want to go. And that doesn't, as I said, doesn't relate specifically to this bill. It relates to this day. So I'm going to stop sharing, although I'm happy to bring up the language for the coordinator again at any point if you'd like to look at it. I also do have one of these tabs here is the rest of LD 393 if you need me to bring that up as well.
Thank you, Anna. So let's start with Representative Meyer. Anything that you wanted to speak to related to this bill?
Well, thank you, Mr. Chair. I think I would start by saying that we have an opportunity here today. We have a number of important initiatives in front of us today. I am very proud to have been a part of LD 1960 and very proud of this committee's work around that bill. Strengthening the office of the Child Welfare Ombudsman was critical, crucial, and but it's not all that we can do in this short session. We have an opportunity here to support legislation that provides investments in the broader child welfare system, incorporating improvements in prevention and in intervention services. And that's what LD 393 is getting at. I, as well as my co-chair, the chair of GOC and the former chair of this committee have worked with those individuals heading up organizations in this state that are here with us today, Melissa Hackett and Deb Dunlap, to produce some of the legislation that's before our committee today. So with that, I would ask, obviously, for your support for 393, because I believe that it is making the investments in a robust child welfare system that our Maine kids deserve and are looking to us to work together to produce.
Thank you. Representative Javner.
Thank you, Senator Claxton. Thank you, Representative Meyer, for those remarks. I do appreciate the level of work that has been put into this. However, I sort of wish that we were doing this after the supplemental budget, to be honest, just because I think there's a few pieces that we're going to see perhaps coming out before us. However, I do have a question that concerning the budget piece of this, the fiscal note, the funding piece. I just really need to have that explained to me in all that we have learned about the opioid settlement, how that funding is truly going to come out of that fund.
Is that something you want to address, Representative Meyer?
I can try, but I believe that what we're asking here is for consideration for, and you're hearing my dogs bark, of course, at this moment when sorry about that. So I'm trying to get to the language here. And I could also call on Melissa and Deb to address this piece as well. So we are looking for the Recovery Fund Council to endeavor to expedite resources for medication-assisted treatment to rural areas through the FQHCs, as well as to expedite the development of peer recovery centers in every county of the state. I believe that the Recovery Council will be reporting back to this committee. And so the idea here was to ask the council to consider these aspects of their work. And I believe that it's well within the guardrails of the settlement language. But that's where we were getting at here.
Okay, thank you very, very much. So then can you just walk me through then what happens with this piece of legislation if the Recovery Council, for some reason, decides not to go this route?
To be honest, I'm not sure I can answer that question, Representative Javner.
Thank you very much. Thank you.
It's certainly well within our ability here as a committee to look at this piece of 393 and consider that we could put this recommendation, this language, this expectation that these funds be directed in this manner into a letter to the council?
And it's just for perspective here, it's a complicated time because we are hearing the budget at the same time. The size of the supplemental budget is maybe changing. And the monies that are flowing to the opioid settlement recovery council are undefined at this point, as is the council itself not populated. So there's lots of moving pieces going on right now. And as I understand it, once we send this bill to, or assuming we pass it, it would go to the AFA table, and AFA could pluck a piece of the bill out and put it in the budget or not, or fund it or not, as the option. So I guess my suggestion is, until I hear other words, that we think about this as standing on its own, because I think the opioid money is going to fund some of the initiatives that people would like, but can't guarantee getting into the budget. So we'll have to see about that. But I think for me, I've settled on thinking of it as a standalone budget, a standalone bill, and deciding whether we want to make it as good a bill as possible and then vote on it. But Senator Moore, your thoughts?
Thank you, Senator Claxton. I guess just addressing that paragraph at this moment, what we are asking them to do is what I think that they are already going to be doing. That's why they're being charged to do exactly that. To develop the peer recovery centers, to expand and expedite resources. I guess I don't feel like we should be putting that into statute, so to speak, or into this bill, because it's pretty hard to say requires them to do it. That's the job that they're going to be doing anyway, because that's all part of why we're establishing them. So, and I know Representative Meyer mentioned like maybe a letter, and I don't have a problem with that, and saying we would ask that for the children or whatever we might do, but I just don't like having it in the bill itself. The other thing I was concerned about too is that looking at the number 1 and number 2, right now there's already 1.5 million for the Home Builders Program that is in the governor's supplemental budget. I know we haven't approved it yet, but it is in there, as is number 2, where it's talking about the Parents as Teachers program. I think there's 2 million in the budget for that. So I think we're being very repetitive if we're already going to have that in the budget, where we wouldn't need to include that in the bill. So those are my comments.
Thank you. Representative Craven?
Thank you, Mr. Chair. I think all this session, with all of the conversations we've been having about child welfare, that this is a tool that we have to strengthen and support the department doing their job of child welfare. And almost all of the parts in this legislation we already have in place, and this is an opportunity to to strengthen and to expand it, and to just try to get a footing and to make sure that our child welfare system is working properly. It's just like everybody has said, really, the Recovery Council dollars and oversight, I think, is slated to be used, to support people in recovery, and no matter how that fares out, that's going to have to be worked on as we go along. And so I'm definitely going to be supporting this, and I think that it's just one more step towards strengthening our child welfare system.
Thank you, Representative Craven. Yes, Representative Stover?
Thank you. I wanted to echo what Representative Craven said. We have worked really hard this session and every session. All of us, I'm staring at everybody's face here, and we all have heard a lot, and we all, I think, have passion about the status of the child welfare system in this state. And I see these initiatives in LD 393 as an opportunity to strengthen the already existing in other initiatives. It isn't replacing those other initiatives. Some of it is contingent on some of the work around that settlement agreement. That's one piece of it. But the other work, when I look at this great big state in 16 counties and I look at the amount of money and I start doing the math, I realize that it's going to cost more than what we have. And this is an opportunity to build to strengthen, to really strengthen and bolster something that we all have seen a need for and continue to see a need for all of our children. So I just want to lend my support to this bill. Thank you.
Thank you. Representative Madigan.
Thank you, Mr. Chair. I just wanted to echo my support for this bill for a number of reasons, but we've all heard for a number of years now the difficulties in the child welfare system. And I hesitate to even call those difficulties because they're tragedies. I've sat on this committee for a number of years, and I've had to look at the police reports of Marissa Kennedy in particular. And I think it's one of the just utmost serious parts of my job to rebuild this system. And frankly, when I talk to people, that's what I hear. The newspapers are full of people recognizing that we need to rebuild the system and do something to protect Maine children. And what I see in this legislation is a collaboration between people who have been working on this for a number of years and have on the ground experience, and they've used the knowledge of how we reformed the system before to put something in place that I think protects Maine children. And I think that is, as Representative Meyer so well put it, that is our opportunity this session. That is our job this session. It's not just Marissa Kennedy and Kendall Chick. How many deaths did we see last summer? So I see this as something that I absolutely support. And I thank everyone who worked on this important piece of legislation.
So to finish up with the committee before we go to any of our guests, thank you, Representative Madigan. I heard a number of things come up. So I'm assuming everybody's pretty comfortable with any language revision that Anna has highlighted in the bill. So I don't think we need to spend too much time there. What about the directions to the Recovery Council? I'll go to the sponsor and say, what's your thoughts about turning that into a letter to the council, Recovery Council?
I'm on board with that.
Okay. All right. And then what about the issue of the budget dollars that's been raised a couple times in different forms? Again, that was the conversation I alluded to about whether this should be evaluated as a standalone bill and let the budget process play out and have things plucked out of it, because once we're done with it, it really is an AFA bill and they can do whatever they want with the bill. We, as we consider the budget, may decide that there are things in here that we want to move in on our own on Tuesday and Thursday and maybe into next week. So I don't want to inaccurately reframe this, but I think the best way to proceed would be to consider it as a standalone, unless somebody has a significant objection to pieces being included in what we're going to end up voting on. Any thoughts about that? Okay, so I'll turn to the guests at this point and see if they have anything else that they think they can contribute that would help the committee in its discussions about 393. And I'd ask you to put your hand up if you want to jump in. Yes, Melissa Hackett, welcome.
Hi, all of you. Thank you for having us here today. And thank you for all of your hard work as it relates to child and family well-being and child welfare this session. I just want to say, I think the conversation is wonderful and in alignment with the discussions we had in developing this bill. I would say that the Recovery Council was the trickiest part, just because that is a piece that's in motion already. I would just mention to folks that the Maine Primary Care Association, representing the federally qualified health clinics, did submit testimony on this. And it speaks a little bit to the need and what we were trying to achieve with this, which I agree, I think the letter could accomplish, but it was really connecting the dots around rural access to treatment and expanding that for families. As you've heard us say before, there's significant crossover around substance use disorder and parents and child abuse and neglect, and really just wanted to connect the dots in terms of the need there with this part of the bill.
Thank you. Thank you. Molly Bogart, care to introduce yourself and contribute?
Sure. Good morning. Thank you. I'm Molly Bogart, Director of Government Relations for the Department of Health and Human Services. And we just had two, I think, quick technical pieces to flag. First, in the amendment for the child abuse, the position to manage special projects to prevent child abuse and neglect, we would ask that that position be titled manager rather than director. That would align with the other individuals who are managing special projects of different kinds from the commissioner's office. if you are interested in moving forward with that piece. And then I know Director Landry also had, I know he's in the waiting room, had some feedback on simply the title on section, I guess the first section around parents as teachers and home builders, that it says 2 million in each year for behavioral health services for families in reunification activities. And I know that those are actually preventative services. So perhaps, you know, he may have a recommendation on that language, or perhaps it's not necessary, but we did want to flag that to make sure that the expectation of those services was accurate.
Molly, that's the part that I said I screwed up, but in a way it doesn't matter because the heading goes away.
There we go. Then perhaps we're all set. But I'll ask Director Landry to confirm.
Dr. Landry, welcome. Good morning.
Good morning, and thanks for allowing me to join you. I'm Todd Landry, Director of the Office of Child and Family Services. I did just want to point out, I know that we have talked, and again, Anna, you may just say that this doesn't matter, and that's perfectly great. I did want to point out that there are two pieces of that title, and I want to make sure that the understanding is clear. The first piece was as it relates to behavioral health services, but I believe the title also refers to quote unquote reunification services. And I don't believe that was necessarily the intent, was for it to be specifically only for reunification services. Certainly we have proposed in the governor's budget, or the governor's proposed in her budget, that we expand home builders to reunification services. Parents as teachers is not necessarily aligned with either reunification services or not. Technically could be used for that, but again, if the header doesn't matter, then you can disregard my comments.
Thank you, Dr. Landry.
I'm sorry I screwed that up for so many people.
If that's the worst thing we have to deal with, the hardest thing to deal with today, it's been a good day. All right. So the only other question I had was about the questions that Anna highlighted that the committee had asked. Does anybody want to go to those and get answers to those, or do you have the information we need to vote on this bill? I'm not seeing any hands up, so I'll take that as a no. All right, any other comments about this bill? Then I would entertain a motion. Representative Craven.
Thank you, Mr. Chair. I would move ought to pass as amended.
Second.
And is seconded by Representative Madigan. Any discussion at this point about the bill? Any further discussion? Yes, Representative Jabner.
Thank you, Senator Claxton. I just want to make it very clear to everyone listening and everyone in the committee room. I think you all know that, my vote, against this motion is not a vote against the policy pieces in this. We care very dearly about what happens in the Office of Child and Family Services, especially in the child welfare system and what we've all been dealing with for the past couple of years, especially this last year. We just think there's a lot of moving pieces that are already in play. And I just want everyone to know that we do support everything the department has been putting into play. And, as we watch this spell out, I personally am just speaking and saying that I agree with the policy pieces. And I think that these things, we'll see them come to pass and come to fruition. So thank you, Senator Claxton.
Thank you, Representative Jabner. I'm not hearing other comments, so the motion on the floor is ought to pass as amended, the amendments being some language changes that Anna will fix for us, the conversion of the Recovery Council conversation to a letter requesting funding, and then that the special projects person be considered a manager versus a director. I didn't check with you, Representative Meyer, to see if that's considered a friendly amendment. Okay, that's considered a friendly amendment. So those are the amended portions of it. And obviously there will be a fiscal note, which makes it another amendment. So we're further amended. Okay. Any other conversation? Any other discussion? Then I would turn to Karen to collect the vote. On LD 393, the motion is ought to pass as amended, made and seconded.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
No.
Representative Lemlin, no. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
No.
Representative Connor, no. Representative Griffin.
No.
Representative Griffin, no. Representative Javner.
No.
Representative Javner, no. Senator Moore.
No.
Senator Moore, no. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So the tally is 6 yay, 5 nay, and 2 missing.
7 yay,
Okay,
5 nay, 1 missing.
1 missing. Okay, so the minority report, Representative Judd or Senator Moore?
Ought not to pass.
Thank you. Okay, so I would thank folks here for contributing to that. Thank you, Melissa Hackett. Thank you, Dr. Landry, and glad you were here, Deborah Dunlap. So, and Molly's always a resource. So with that in mind, I note that we haven't given Representative Griffin a chance to introduce herself.
Thank you, Senator Claxton. Good morning, everyone. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Levant, and Kenduskeag.
Thank you. Okay, and I also note that Assistant Attorney General Ariel Gannon is with us, and I just want to give a minute for her to introduce herself and describe her role in these conversations. So welcome to Attorney Gannon. Good morning.
Good morning. Thank you for having me here. I think I missed a little bit of what you just said, but my name is Ariel Gannon. I'm an Assistant Attorney General and I'm Chief of the Child Protection Division. I'm happy to be before you and be helpful as needed.
So I asked if your particular role really is to help us with the legal aspects of any of the material that we consider.
Well, I can certainly do my best
Yeah.
to provide some feedback.
Yep. Okay, so your resource. So thank you for being here. And I just want to make sure the committee knew that she was out there as a resource and that she had a chance to introduce herself in this work. Thank you again for being here.
Thank you.
All right. So that would move us to consideration of LD 1824, which has an amendment.
Okay. Hopefully you are looking at 1824 there. You are looking at 1824, correct?
We are.
Okay. So this bill was a concept draft about child welfare ombudsman, but it has been changed by the sponsor, Representative Stover, to propose that the Maine Commission on Indigent Legal Services establishes a pilot program to provide legal counsel to parents and custodians as soon as the Department of Health and Human Services begins a safety assessment to determine if a child is at risk of harm. The pilot would begin in District 4. It would last for 2 years from January 1st to 2023 until December 31st, 2024. And then the Commissioner on Indigent Legal Services would submit a report to the Judiciary Committee because the Indigent Legal Services usually comes under their jurisdiction. So the report would go to the Judiciary Committee with information on costs, estimate to expand to the entire state, the number of families served, the extent of services, number of hours and outcomes data, and it obviously has a new title. You did hear during the public hearing that currently parents only get legal counsel after the department has filed a petition for a child protection order, and petitions are sometimes accompanied by a preliminary protection order, which removes custody from the parent and entitles them to a summary preliminary hearing. The pilot would have the Commission on Indigent Legal Services provide legal counsel as soon as a safety assessment is opened. And the intent would be to reduce the number of cases filed, increase services for parents, and result in better outcomes, and provide parents with advice on likely consequences. You did hear from the Commission on Indigenous Legal Services that they can support the bill as long as the additional staff is funded, but that it would need the bill would need a statutory there would need to be a statutory change, since Indigent Legal Services only provide services once a case is opened. I forgot to move my thing down. I'm sorry. So there is that drafting issue to sort out. This was a recommendation from the MCWAP report, and there was a question about states with similar programs. There is a Casey Family Foundation pre-petition legal representation report that I sent you about a program, about a number of programs, including one in New Jersey that has been receiving referrals since 2018, some parts of Oklahoma and Iowa. I don't know a lot of the details of those, but I did send you some of that. This is just some of the background of the law for you. I think it's this definition in subsection 4 of Indigent Legal Services that would require the statutory change. I also just want to make sure that you know that that Justin is here from Indigent Legal Services in the waiting room if you need him.
Thank you for that. So the sponsor. Thoughts about that analysis? Comments?
Yes, thank you, Mr. Chair, and thank you, Anna. I think that this bill provides an opportunity. It is not something that currently exists, as you know. And during that PPO, that initial assessment period, there is no opportunity for representation. And if you cannot afford representation, which I would say many of the parents who become involved in child protective services cannot afford legal representation or counsel, you're thrown a lot of information at once during one of the most traumatic and emotional experiences you've probably had in your life. If you have a history of trauma yourself, the re-traumatization of involvement with the department and the idea of losing your children and whatever other things that are going on in your life make it nearly impossible to comb through the myriads of information and emotions that you're experiencing. And you only have 30 days to sort this out. As a previous director, state's director for domestic violence and sexual assault, I saw many instances where victims of domestic violence who were not the predominant aggressor, not the offending parent, would be facing child protective services and the potential of losing their children because the offending parent was either still in their lives or in their home or both. And this would provide an opportunity for indigent legal services to be made, and this is one example, to be made available to that non-offending parent so that they could protect both their children and also not face losing custody of them because of the situation that they're in, and provide a mechanism where they could start to rebuild their lives together. I just want to encourage the committee it's a thinking out of the box. I think that the MCWAP report really on page 16 lays out a good rationale for this. And I invite Justin to come in and talk to us about indigent legal services and the way in which it could address this 30-day assessment period, PPO period, whatever we're going to call it, the initial phase of the assessment in child protective services, and how we could have an opportunity to do a pilot and see if we could gather data that would show we really could build some positive outcomes by strengthening families this way. Thank you.
Thank you, Representative Stover. Representative Craven?
Thank you, Mr. Chair. kind of a technical question. Maybe I should wait until Justin comes in. It just dawned on me that indigent legal services struggle constantly for the lack of funding, and whether or not we should be adding a fiscal note to the bill.
Very good. So good timing, because we've been joined by Justin Andrews. Welcome, sir.
Good morning. Thank you for having me. Would it be
So
better?
I think, you want to go ahead and respond to the questions?
Yes, thank you. In broad strokes, MCILS has not taken up this bill formally, but the Commission has discussed in the past the need for early intervention and access to counsel favorably. And staff position is that this is a service we should be providing. It's going to come with a big caveat about our ability to provide it in just a minute. But without hesitation, I think that families are entitled to this representation in addition to being well served by them. And I think that families would in fact be very well served by them. There are a host of problems that come with these early interventions, ranging from the simplest aspect, which is that parents often make uncounseled admissions that are then used against them. In the context of a criminal case, that would be categorically inadmissible. But here, the department often has questions for parents or seeks information, and it's presented in a way that if the parents don't participate in that assessment, then the department will take hostile action. And so it's coercive, similar to a police interrogation. But the result is that the parents make admissions that are then used against them. And so that's problematic. The other thing that's problematic is that it's often the case when we see preliminary protection orders at the beginning of a case, or we see jeopardy orders going into a case where the failure to comply with a safety plan that was part of this uncounseled process at the beginning of department involvement is used as a basis to demonstrate that there is some form of parental unfitness. And just so some of you haven't had the opportunity to meet me before, I did child protective work as an assigned counsel from approximately 2002 until 2019 before closing my private practice. So I saw this many, many times as a practitioner, in addition to seeing it at a system level here. I think the Commission would be supportive as a whole, but certainly the staff position and my position as a former practitioner is that this legislation is necessary to safeguard parents' rights, and that there's what amounts to a due process problem without it. And just to respond to what Representative Stover was saying. In terms of our ability to do it, the numbers I received from OFCS were that in 2021, there were an average of 84 assessments per month for a total of 1,008 assessments. And that in each of those assessments, it is frequently the case that we need to assign more than one attorney because there is more than one parent. And often there are more than two parents. There may be separate fathers, maybe separate mothers of different kids. And so they recommended that they thought that their caseload supported about 2.5 attorneys per assessment on average. And I don't quarrel with that. That would mean 2,520 assignments a year. For a frame of reference, most of these cases don't reach court. And so what we've seen in this calendar year 21, because that matches up with how OFCS provided the data, calendar year 21, we had 272 attorney assignments for child protective cases. This excludes appeals. For trial level child protective assignments in the district you're talking about. I'm going to slip and say District 6 because it's Judicial District 6. And so if I say that, please bear with me. Same courts. It's a lot of additional assignments. There are two impediments that I hope you'll help us solve so that we can do this. The first is there should be a fiscal note associated with it, and it should be about $1.5 million based on the work I think will happen at this stage. The other thing to bear in mind is that we have 50 attorneys total currently eligible and accepting child protective cases in these four courts. So that would mean that there would be more than 50, slightly more than 50 assignments per attorney for this program, which exceeds what our upcoming caseload standards would permit. It also exceeds what they're capable of doing as rational humans. And that's presuming that they're doing only this work full time, whereas most of these attorneys are doing multiple forms of our work or other work and or in other courts. So just for a sense of the scale, there were 3,426 assignments in child protective cases statewide for calendar year 21, and there would be 2,500 assignments just in these 4 courts, just in this program. So we need to make sure that we're funded to do it if we do it. It's not your bailiwick. I've been talking to judiciary about rate of pay, but we need to incentivize more people to join the program, because the bill as written, part of the report is going to be, we did the setup or ultimately unable to staff the cases. And so I'm happy to answer technical questions, and I would very much like to see parents have this right of access. I think it's important.
So just to address a couple of technical questions, the 1.5 million was to cover the entire state, or to just this district?
That's correct.
Or this region, okay. And one of the questions that has been raised is whether we ought to be looking at doing a district, since this is a pilot, or a number of families. Do you have any thoughts about, we're trying to figure out, if this becomes a pilot, what number do we have to get to learn from, so that we can then make the case about expanding or contracting this resource? So
I've had to learn over my first year of being a bureaucrat to never let the good be the perfect be the enemy of the good. I'm tempted to say I have trouble with it going to specific families, because I don't know who does that selection. And it feels like an equal protection or due process problem to offer this resource to some, but not to all. But I would never stand on that if we could assist a single family in this way. And so I think practically, and it may be that my perspective on this is a little bit different than Representative Stover's, maybe we start in a court if we can't do a district. We're gonna have the problem scales, right? So we have fewer people in each court. On the other hand, the 50 attorneys who are listed in those 4 courts are often listed in at least 3 and maybe all 4 of those courts. And so it doesn't scale perfectly. Yes, the $1.5 million estimate is against just the District 4 pilot program, assuming something like 2,500 assignments. Okay. So the thing is that there's less legal work to be done, but all of the initial work you do with a client to learn their story and their background, to develop resources, develop rapport, all of that will need to happen to do this effectively. It won't have to happen again in the first stage if it becomes a case. So there'll be savings in some cases in the next element, but it's actually a bit more work than you might anticipate. And if I may be so bold, I see that Attorney Richter is present. He also does this, and it'd be interesting probably for the committee to hear his perspective on when you spin up that work and how much of what we would think of as the initial litigation work does have to be done to provide this initial support. But I think it's most of it.
Okay, before we go to Attorney Richter, thank you for being here, sir. I want to hear from Representative Madigan.
Thank you, Mr. Chair. I've worked with families involved with the child welfare system, both parents, kids, for decades. I see this as an improvement, because one of the big gaps that I've seen is parents involved in that first initial process. You know, a report has been made, there's the Child Protective Services is doing an investigation, and particularly for those parents who are challenged in some way, whether they have some reduced intellectual functioning, whether they have an active behavioral health or substance use disorder, physical challenges, all of it. It's a pretty confusing and overwhelming thing, and they can't get any legal advice on it. I think it's particularly a problem when there's 2 parents involved, and one parent may be the offending parent. Perhaps there's some domestic violence issues, or perhaps one parent has been accused of sexual offenses, and the non-offending parent is caught in a pretty precarious position. And I think that having some legal representation, at least having some legal consultation, can lead to better choices being made, and that person feeling less alone. The alternative is what I saw happen too often, which was, the case being, findings found and children removed, and eventually going to termination of parental rights, which I would like to remind everyone is always a gross tragedy. Even when kids are removed from families that are not caring for them adequately, they always have a sense of loss. That is not something that is solved by adoption in a nice family, in a nice house. It is always a great tragic loss for them. It continues to be a great tragic loss for that non-offending parent who just didn't know how to get what they needed to get done. And so I think getting them some legal representation so they can really truly understand the risks of not doing anything and getting connected with what needs to happen can actually benefit families in a way that is not happening now. So I am supportive of doing a pilot about this because I think we need to. Thank you.
Thank you. Representative Zager?
Thank you, Mr. Chair. I appreciate the Attorney AAG Gannon and Attorneys Andrus and Richter being here. What would be some of the indicators that that this pilot or this program is working? I presume the families that are kept intact would be one, but with all your experience, what are the things that you would be looking for that New Jersey or Iowa or other places where this has been done have been tracking over the last 3 or 4 years that they've been doing it?
So I'm not able to answer the question about how the other states are tracking. I'm sorry, I can follow up on that, but I'm not prepared for that question. I can answer what I'd be looking for, which would be a decrease in preliminary protection orders, particularly, and a decrease in removal. So that there are options through the court for departmental involvement and court involvement, should that become necessary, that involve jeopardy and oversight, but the children remain with the family. That'd be the first cutoff. We should see fewer removals. Then, for those cases, for those families that have the benefit of early counsel, we should see fewer court cases generally, in my view. We should see fewer cases proceeding, because there are a lot of families where there isn't some grossly hostile act. There are a lot of families where there's a lack of parental education, or there's substance abuse or mental health issues, or frankly, there are pure poverty issues, where early intervention and assistance in navigating the program, and let me be clear that my lawyers are not social workers, but we do a lot of social work. And if we can assist with that, now as part of a broader program, you'll hear someday MCILS asking for social workers, actual social workers, to be on the parent side and engaging in other parts of that process for all the same reasons. But those are some of the metrics that we'd be looking for: decreased removal, fewer PPOs, less court involvement overall. It's going to be difficult to see in the numbers, because when you look at 84 cases a month entering the system in this way against 67 overall, resulting in 272 attorneys assigned, the change is going to be fine, because most cases already don't result, most services cases already don't result in court cases. So to answer Senator Claxton's question, I never quite came back to, is how big does the sample be to become statistically meaningful? I don't know how to answer that because I'm not a statistician, but big enough to ensure that an improvement doesn't get lost in the noise if when we're looking at, when we're looking for that change. The changes are also ineffable in the sense that we should see, where there is removal, reunification sooner, or we should see reunification with a parent sooner. We should see family reintegration overall, generally. I come from a family where 3 of my 4 siblings are adopted, and they were adopted into a good family, and we had a good life. Where they're all young to middle-aged adults now, and they're all still addressing their experience, even though their experience from the outside was a huge net positive for them. It is deeply traumatic when this stuff happens, and we should start to see the incidences of that trauma and the sequelae of that trauma decrease, even for families where those are ultimately the outcomes, if the parents can be involved in making some of these productive changes at the beginning.
Thank you. That answer your question, Representative Zager?
Yes, it does. It gives me a sense. Thank you very much, Mr. Chair.
Attorney Gannon?
I just wanted to provide a little more context. I mean, just to work with the numbers a little bit, we're talking about D4. So as Justin indicated, about 1,000 assessments last year alone. And of those, 7% ended up in court cases and 3% ended up in actual removals. So not all court cases themselves end up in removals. There are a lot of menu options, if you will, on how to intervene with a family unit to make sure that children are safe. You know, what was characterized as a hostile action is a request for a preliminary protection order that does not always, the request that comes with that is not always a request to remove the child from their family unit. Sometimes what happens is it's a request to have access to the family to appropriately assess. And one of the concerns that I think I have is that there would be an increase in those types of filings if overall there would be a reduction in filings for custody of the child, just to have access and to go through the required assessment activities to make sure that the child is safe. So I wanted to point that out, that, you know, these are requests to the court for judicial intervention to take a look at a petition that's written and supported by affidavit, and then the judge decides whether the department has met the statutory burden of removing a child or even having access to the family. So there's certainly options available there too. And I wanted to provide that that kind of context as well. Certainly answer any other questions if you think that would be helpful.
Thank you. Attorney Richter, will you kind of introduce yourself and address any of these issues? I'm not hearing you, sir.
Thank you, Senator Claxton, or Chair Claxton, and also thank you to Representative Stover and Representative Madigan for, I think, very important comments about the importance of preventing removals. I mean, they come with a great deal of trauma at all points in time. And really, when we're talking about pre-petition representation, and I will address kind of like what I think is the kind of amount of time that I would generally put into that. But we're not, I think when we're talking about what we can do to create a solution for the family, and when we're talking about like a domestic violence survivor or somebody or sexual abuse in the home or something of that nature, a lot of times what the attorney is going to be doing is going to the non-offending parent and advocating for a protection from abuse or some sort of alternative that can protect that child, keep that mother with the attachment relationship with the child intact, and oftentimes their coercive relationship is going to lead them to make a bad mistake, violate a safety plan, something that, and again, those are unilateral, kind of the department comes in, says you have to sign this, no contact with this offending parent. And the wording of those safety plans can be incredibly important. I mean, one word could be the difference between a violation and keeping a family intact, and a preliminary protection order can follow from those types of safety plans. So the amount of importance on pre-petition representation is greatly understated. I mean, I think like when we're talking about, I think the Detroit Family Advocacy Center was able to prevent 95% of petitions from being filed based on pre-petition representation. And so that's often just giving good advice to the family. How do we deal with this situation? How do we protect the children? Because in all of this, the attorney is not going to be advising the parent to do anything that is going to compromise the safety of the child. We're there to prevent the preliminary protective order. We're there to keep the family intact. That's our goal. So I don't think it should be looked at as like adding an adversarial player into the mix here. I think it is, how do we wrap around this family and provide good advice, and how do we avoid those removals? I would say, so we're going to increase the safety of children. We're going to decrease the removals and PPOs that are filed. We are going to increase access for the department, because we're not going to tell the parent, you know, clam up and don't, we're going to be there while they have those discussions so that the parent feels comfortable, and we're going to know where that conversation should go and focus it on child safety. But in my experience, when parents that do have the means to hire an attorney, it isn't a tremendous amount of work. I do think that, preparing that for a PFA or something like that is kind of standard, and that might be 10 hours of work on a family to prevent a removal. But what we're doing when we do that is we're preventing a filing, we're preventing 2 or 3 appointments of counsel, we're preventing number of court cases, we're preventing the potential that this one thing that went wrong never gets redone, and then it ends up in a termination of parental rights. And like I said, the trauma from the removal, the trauma from the apprehension of the child not knowing what's going to happen over the course of however many months it takes in order to reunify the family, that's incalculable. And so I think that there's not only a huge amount of safety that can be implemented just by getting them pre-petition representation, but I also think there's the reduction of trauma for the child, and then we have a savings from the amount of court cases we're able to avoid, and also reduce the caseloads of the appointed attorneys. And so we're kind of saving commission dollars, and we're saving judicial resources. We all know that these cases are a heavy burden on the district courts, and so we can reduce that as well. And I would also just to say that I think that the area that Representative Stover has put forward is an area that we really do need more services. We need more access to services. That's one of the most difficult counties, some of the most difficult counties that I work in to get services for clients. The wait lists are huge. Oftentimes the services for children are non-existent, but we have some familiarity where the parent probably does not. And how do we get that service for that child that needs it, and that family that needs it, in order to ensure safety and prevent removal?
Okay, thank you. Representative Connor.
Thank you, Mr. Chair. I don't know who this question would be for. I'm just posing it out there, but is there any data on current services being provided by some of our excellent nonprofit legal services like Pine Tree, Maine Equal Justice Partners, and the Volunteer Lawyers Project? Are any of those entities providing any of these services for these clients or these customers, or is it strictly just they either have to pay a private attorney or they get no representation?
Attorney Andrus, do you have some information?
Yes, thank you. So, excuse me, typically legal services organizations do not provide services in child protective cases directly. The exception in some instances is the Cumberland Legal Aid Clinic attached to the law school, where they are sometimes involved in child protective cases. Those organizations do provide, in some instances, services for plaintiffs and protection from abuse matters, for example. And so there is some crossover, but it's not well integrated. One of the big problems is that, to my knowledge, all of those organizations provide services only to plaintiffs and don't represent accused offenders. And from my perspective, we need to be careful as we talk about this to ensure that we're not prejudging the underlying merits of a domestic violence claim or anything else. We need to be protective of the potential that it's true. We also need to be cognizant that in most of these instances, not all, most of these instances, the alleged abuser hasn't been subject to process to reach a resolution as to whether those events occurred as alleged. And so I think that answers the question, also extends a little bit into why it's a little complicated.
Does that answer your question, Representative Connor?
Yeah, like I said, I didn't know, so I was just trying to figure out if those services are being provided by some of our excellent nonprofits.
Thank you. Attorney Gannon?
I would add that, domestic violence clearly seems to be at the forefront of many minds here today. And, our office has partnered with Pine Tree Legal Association. We meet frequently. We've been rolling out trainings for caseworkers in collaboration with Pine Tree Legal Association. So referrals to that organization can happen earlier and more with more agility to meet the needs of parents in the way that's being described here today. So that's definitely something that our division has been working on, and in collaboration with OCFS, recognizing the very difficult dynamics that happen, that happen in the initial stages of an assessment. So I hope that allays some concerns about, identifying domestic violence as an issue and connecting families with resources, including legal resources, earlier.
Thank you. Attorney Victor?
I was just going to address the fact that, Pine Tree does a great job with protections from abuse, but they're not going to represent the defendant. And oftentimes, if I'm getting appointed to a pre-petition case, my goal is to explain that to the alleged offending parent, and then we can kind of maybe work on what the resolution is, what the contact schedule is, ensuring that there's a safe and appropriate contact schedule even for the non-offending parent. I mean, that's just something that Pine Tree it's not a line that they would cross. And so I think there's a huge gap in that. And I also think that the idea that there's a department filing coming, it dissuades any nonprofits from really wading into that pool, because it's not what they do. And so the dedicated kind of attorneys that do this child protective work understand kind of what the consequences are to each course of action, whereas these nonprofits, which are kind of siloed out, aren't necessarily going to have that, and they're not going to be comfortable to kind of get involved in a pre-petition case like that.
Thank you. Before I go to ask the department a little bit about their sense of this, I'd like to give Senator Baldacci a chance to introduce himself.
Good morning. I'm Joe Baldacci. I'm from Senate District 9. I represent the city of Bangor and the town of Herman. I appreciate it.
Just lost your audio.
Can you hear me now?
Yes, that's better.
Okay. I represent Senate District 9, which is the city of Bangor and the town of Herman. I was bouncing back and forth with the Appropriations Committee on the state and local government budget. I appreciate your indulgence. Thank you, Mr. Chairman.
And we're in the midst of discussing LD 1824 and what it would take to right size, to learn from a pilot, and some of the other stipulations. The Molly or Dr. Landry, do you want to weigh in on the potential value or not of this particular bill?
Sure. I might ask Dr. Landry to offer some comments. I think, there might be some misconceptions we'd like to clear up.
Very good. Dr. Landry, welcome back.
Thank you, Senator Claxton, and thanks for the chance to offer some comments as it relates to this bill. I would reiterate something that I believe our colleague Ariel Gannon had pointed out. And some of the numbers I believe that Mr. Andrus pointed out. 1,000 investigations a year, or 1,000 investigations last year. Only 7% of those ended up with any type of court involvement, and only 3% of those ended up with any type of or a removal. I would certainly say that one of the things that we always strive to is to try to remediate and deal with issues so that a court involvement or a removal is not necessary. And I think those numbers indicate that to a significant degree, I believe we're doing a very good job of that. As it relates to size and scale, with 3% ending up in removals, even a 10% reduction in the number of removals would be 3 children. And while I'm not saying that that is insignificant at all, because for that child it might be very significant, I think it is also important to point out the scale and scope of what we are looking at here. The only other piece that I would indicate is there have been some significant discussions in this committee, and it was brought up during the Casey Family Programs and Collaborative Safety Review around some of the challenges that are sometimes present in cases as it relates to the sharing of information and the participation of parents when it involves some behavioral health or mental health providers. That was documented in their report, and I refer you back to that. One of the pieces that was discussed in that is the question of why is that? And one of the answers that came about as a result of that was that sometimes the behavioral health provider or the substance use provider, treatment provider, sees the parent as their client, regardless of an impact on child safety. That is something that we are working towards addressing, and believe that that is something that we can work more effectively with our behavioral health providers and substance use treatment providers on. As it relates to attorneys, and while I'm not attorney, I'll certainly refer to Attorney Gannon and others who can speak to this. Their, I believe, ethical obligation is to represent their client, and their client in this case would be the parents. And I think that is something that is worth at least pointing out. Again, I'm not an attorney, but I'll just point that out. My experience in other states and in working with other states where this has been a program that has been piloted or put in effect, that has been an issue that has come up, and I believe that's even addressed in the Casey report as well. Not to say that it can't be mitigated or worked with, but I do want to point it out. So those are a few of the perspectives that I would say, and again, I will start or end where I started with the fact that the vast majority, vast number of investigations do not end up in a court involvement, do not end up in a removal, and in large part, I think that's due to the significant work that our staff and others, providers and others do to ensure that those safety issues, if there are there, can be remedied and ameliorated without the involvement of the courts or a removal situation.
Thank you, Dr. Landry. Attorney Andrus?
Thank you. I hope to just address very quickly two things that I heard from Attorney Gagnon and from Dr. Landry. First was the use of the word hostile. I mean, hostile is a term of art, but when the state is involved, even in an assessment of whether a parent is discharging that parent's parenting duties appropriately, the state has begun an investigation into a fundamental liberty interest. And that is a fundamentally legally hostile, even if it's not hostile on an interactive level situation. It is certainly the case, as Dr. Landry said, that the attorneys would represent the parents. They're not social workers, guardians ad litem. They don't represent the children. They are there to represent the interests of the parents. And I would suggest to you that that's their appropriate role. Now, a diligent and appropriate attorney is going to work with the parent, to work with the other players to achieve the best possible outcome for the parent. But that role is not being served at this time. I don't think it should be concerning to the committee that an attorney assigned to represent the parent would in fact represent the attorney's interests. If the attorney is misbehaving in doing that, then I need to know about that so I can counsel them because they should be working cooperatively.
Representative Stover.
I think that I wanted to ask if Deb Dunlap could be brought in. She worked on the report, the MCWAP report that recommended this, and she could speak to some of the work that they did, because we're really talking about access to due process. And maybe she could speak to the work that MCWAP did on this. Thank you. Or Melissa Hackett. They're both here.
She's on the way. Attorney Richter.
Thank you, and I would second that. I think Deb Dunlap would be able to really elaborate on some of the MCWAP stuff, which I'm actually a panelist on. But just to address Dr. Landry's statement, I mean, just because a specific assessment doesn't lead to a removal doesn't mean that family doesn't have repeated assessments. And so I think if Dr. Landry were to ask his staff on the ground, they would say this could be a helpful situation in a lot of different assessments, because oftentimes I get calls from parents or other players that have been referred by department employees saying this person needs an attorney. There is no attorney available to this person, but they need to either file some sort of parental rights action, or they need a protection from abuse, or I get lots of referrals that way. And I also think that there's a lot of situations in which parents have to make a immediate on the ground decision. Am I going to do this thing? Am I going to pack my bags and take my kids and go to my mom's house, or am I not going to? And oftentimes they might do it. They might agree to a safety plan, and that safety plan might only work for 1 day or 2 days. And then what? And so then they're back at the same spot where, you know, they need somebody that they can consult with to say, is this the right thing to do? Is there some other protective measure I can take? And they don't have that at this point in time. And so I think that the number of assessments and then the filings based on that number of assessments is a little bit misleading, because families can have repeated assessments. And I see that all the time, where families have kind of constant issues because the issues never got addressed in the assessment. And so they're left in the same spot that they were when the assessment began. And we can have direct impact in access to services. What does this family need? What does this child need? What does this parent need? It's not just representing the parent. That is my goal. That, you know, I have ethical obligations to represent the parent, and I, you know, you have to follow your ethical obligations, but you're also looking for, as a problem solver, and how do we kind of alleviate the situation? Because my client is not better served by leaving them in a precarious situation, or a situation in which the department might just come right back and take the child. And that, you know, we want to resolve this situation so that it is safe, so that the family is intact, and that they have access to those services.
Thank you. Attorney Baldacci?
Thank you, Mr. Chairman. I just want to, first of all, say how much respect I have for Mr. Andrus and the work he's doing at the Maine Commission on Indigent Legal Services. That is a huge task, Justin, and I can only, as a member of the legislature and as an attorney, I just want to thank you, because that by itself is a huge public service. I do want to say that having the attorneys involved, as somebody who's done this for 30 years, and I've been involved in child protective cases as a general practitioner, I've done a wide variety of cases, but we still do some child protective cases, not court appointed, but having an attorney at the outset, in my experience, would be helpful to give clear-eyed legal advice to parents. And if it can avoid the trauma of removal, or help the department work better with an individual. Now, you know, when an attorney is assigned to a case, you know, we could be assigned to somebody that's very, and I like I said, I don't do court appointments anymore, but when an attorney is assigned to a case, he could be assigned to a very difficult person, typically in a child protective or a criminal aspect. The attorneys, I assume that many caseworkers would welcome the attorney, because the attorney can often provide help in reducing the temperature of a case, okay, which often needs to happen, and trying to make it a more constructive dialogue. So I really think it could be helpful. I'd like to see the pilot program go forward. I'd like to see the results of it. But I don't see how it's not going to impede the department. And if anything, it should help the overall process, which is both about protecting people's constitutional rights as well as protecting children. So I think that, you know, obviously I'm an attorney, so I have a jaundiced view of the situation, but I think from experience, this could help avoid the trauma of removal. And even if it doesn't do that, I think it could help reduce the temperature of cases. There are cases can go from white hot, they need to be brought down so people start listening to each other. So I see it as a positive. I really thank Representative Stover for putting forward this bill, and I wholeheartedly support it.
Thank you, Senator Baldacci. Did you want to contribute here something, Deborah Dunlap?
Yes, thank you, Senator Claxton, and thank you for having me here this morning to be able to comment on this bill. So I'm, as you've all seen me a few times these past few weeks, I'm currently the co-chair of the Maine Child Welfare Advisory Panel, and Julian is one of our members. And so I can speak a little bit. I'm not the content expert in this particular recommendation, but I can provide the committee with a little bit of insight about the conversation that happened when some of the committee members put this forward. So the original the sort of inspiration for the recommendation that was in the report was actually based on some parent survey findings. So the parents were asked how well they felt that they had their the expectations and what it was that they had to do and how to participate in their case explained to them at the beginning of their case by the caseworker, because this was a question about the assessment process. And only 15.5% said that they felt like they understood what was happening. So again, we have, over 20 members with a wide variety of experiences. And we talked a bit about, we know that there's a bunch of reasons for that. It's a traumatic experience. But again, at the beginning of the case, there really isn't anyone, it's the caseworker that you're relying on. And so by the nature of that this is the person who is coming in and saying there's something significantly wrong that you need to change. And that person also is in the same role that will remove the child if you don't change. And so just by the nature of it, it's unlikely that the parent's going to feel really trusting of that person. What we know, each one of our members in the conversation, folks were saying the main goal, the reason that the department is getting involved is because something isn't going okay, right? Something needs to change. That's sort of the underlying understanding. And that when, if there isn't anyone who can help the parents to truly understand it, that they feel like is on their side, it can be more difficult to inspire that change at that particular part of the case. And so part of what our members were discussing is that getting earlier representation of someone that they know, like just by the nature of the role, they know they're on their side, who can also deliver the truth. And I think you've heard Julian and Justin both speak to this. The role of the attorney isn't to cover over what the parent is doing. It's actually to help them see what they need to do in order to prevent the removal. And those are really difficult conversations. The best parent representatives that I ever partnered with and that our members have partnered with are the ones who are able to say, you need to do this. This is the significant change you need to make in order to make the department go away. You're going to have to do this really hard thing and change this element that is making your child unsafe. So again, sort of just, I'm hearing some of those same concerns. It does seem like it would be helpful for you to understand that this was something that the members did talk quite a bit about before voting to make this recommendation in the report.
Thank you. Yes, so Dr. Landry?
Yeah, thank you very much. I do want to just point out very, very quickly and briefly two pieces. What Deb did not indicate was the survey that she was responding to, just to be clear, included all of 33 responses, I believe, of parents. And while I value the perspectives of those 33, I think it's also important to note of some of the limitations before any broad conclusions are drawn as it relates to that. And you may also be interested to know that this topic was significantly discussed at last Friday's MCWAP meeting, the Maine Child Welfare Advisory Panel, and a number of barriers were discussed, not just the ones that may have been alluded to in the previous comments.
Thank you. Attorney Richter?
Just to address, one thing that one of the other members just emailed me and let me know that Pine Tree Legal won't give any legal advice on a pending child protective action, which is consistent with kind of their roles. And just to address the MCWAP survey, I think it stands to reason. It is my experience that parents are not necessarily hearing the department the same way that they're hearing me when I'm having that conversation. And part of it is that I am not kind of a kind of a person that is going to take action against them. I'm not putting them in that situation that is causing them stress and anxiety and fear and all of those kind of things that are impacting their decision making. I'm only there to tell them, like, this is the advice that I have based on my experience, and this is what the department will do. If you don't do this, this is what is going to happen, or this is the course of action that you could do, and this is how we can address the same situation. So again, all of these things are related to child safety. I think that no parent wants to see their child hurt, and no parent wants to have their child removed. And so, like, how do you work with them? How do you get them to understand that? And a lot of that is stuff that the caseworkers don't have the bandwidth for. I'm there to listen to them. I'm not a social worker. I used to be a social worker. I provide a lot of social work in my representation because that's what parents need in those situations. They need to be able to have that voice. They need to get their story out before I tell them what they should be doing or what they need to be doing in those situations. And so they're not going to open up and tell the department that. It's a different role. The survey that MICWELP did is entirely consistent with what I see, which is that they hear these things from their attorney. Their attorneys are able to explain consequences, make them understand the situation they're in. They're not getting that from the caseworker, and nor should they. So I think that is the role that we would serve.
Okay, thank you. Deb Dunlap.
Thank you, Senator Claxton. Just to respond to Dr. Landry, I just want to make it clear that we recognize that it was a small sample size, and the panel did have that conversation, and we hold a really core value that 26 parents are just as important as a greater number, and that these are consistent messages that we're getting. There were also 100 providers that provided survey feedback that was pretty consistent also with this issue of parents not understanding how to participate in their case and what they needed to do to change, and providers also being a little bit unclear about how to help that. So by no means does the panel think that this one particular thing is going to fix all of these issues. That's part of why at our last meeting, we were digging more deeply into how can we all work together to make sure what are the various roles that can help parents understand what they need to do to change and how to participate in their case. But ultimately, in the end, again, the panel thinks that this is one of the important tools that could really to support parents to understand what they need to do to change at the beginning to maybe prevent some of the trauma to kids in the long run.
Thank you. Representative Madigan.
Yeah, I just want to speak to a number of people
You're speaking to the bill, right?
Yes. Talked about the role of social workers. And, I've been that social worker who's working with that parent that's involved. And we also have those difficult conversations with parents, but we're not legal representation. And we certainly can recommend kind of what needs to be done to meet what the department wants to see happen, to maintain custody of their children, or to meet what the department says needs to happen for them not to be involved anymore. But that cannot replace kind of the legal representation that needs to happen, so that can be spelled out what that process is. That is not what my role has ever been, or anyone a provider who's ever worked with families involved with child welfare. And it's really important to have that legal representation. Thank you.
Thank you. So a question of Attorney Andrus. The agenda here is the creation of a pilot study. The social scientist part of me says that removal and proceeding to court are roughly crude measures of success, but they are measurable, so we tend to gravitate to them. What about what other things could you be measuring? And the basic question is, do you think you can set up a worthwhile pilot from which we can learn something at a time that the sands are changing underneath our feet as we talk?
So the answer is yes, we can set up a worthwhile program, so I'm not multitasking here on both screens. And so we can do that. We need, in order to do that, we probably need a staffer here, ultimately, for all of these assignments and to manage the data. We're going to need insight into what actually happens in the specific cases. Due to the confidentiality rules, we can't get information from the courts typically. And so we don't want to overburden the attorneys by making their reporting requirements so onerous that it detracts from their ability to provide services. But we would need to do that. One note of detail from the bill, it says in section 1.1 that we're to provide legal counsel in the same manner as we would do it now. And that would need to change because now the court assigns counsel typically, but the court won't be involved. So there'll need to be some direction about how we're to receive the information to do those internal assignments. It's probably 20% FTE to staff these cases to get the assignments done if we're doing it at the level that we're looking at here. And so it's time consuming because when we just so you understand, when we do that, we've got to reach out to counsel, see if they're available, figure out who else is involved, clear all the conflicts. And it's not as simple as, checking the next person on the list. And also, so you know, and in support of the judiciary, it's not any more simple for them when they do it. I think time in the system would be a metric we could measure. The ineffable measure that I think would be hardest but most meaningful really is the psychiatric well-being of the kids and the parents. And as Julian said, although I said that we represent the parents, in doing that, we're looking for a holistic well-being. And unless the case is so bad it just becomes litigation, that's never the goal. I don't know how to measure. I don't have the social science background myself to be able to know how to measure that sort of measure empirically what feels like a subjective outcome in terms of qualities of life. But there may be a way to do that. We would certainly participate in that. But we would need to deal with the data collection. And for us to be able to report that out, we're going to need a staff person to do it. It could be a limited duration thing. This is really judiciary's problem ultimately, probably, but it could be a limited duration thing since it's a pilot program of fixed duration.
Thank you for that information. Representative Stover.
I had a follow-up question for Justin around those measures and the 20% FTE that would be required. Would that be all of the costs to your office, the 20%, or would it also include some additional resources, for instance, your time designing and doing data collection to be able to report out? Is that included in that 20%? Or is that something, is the 1.5 the total that would be required to do this pilot? Have we
1.5, I'm sorry to cut you off. I was anticipating. The 1.5 is the attorney fee cost, I anticipate, based on 2,500 assignments or so against what they typically cost. Again, there'll be some savings. Julian, excuse me, I know him, Attorney Richter pointed out that, there might not be as much as I thought, but then he was also talking about doing PFAs under the aegis of the program. So I support that, incidentally, on both sides. Bring them, defend them. But that's time that's got to get done. So I don't think it's really going to drive down the average voucher price for us. What we're going to be doing is adding a voucher to each case and then adding a whole rack of them. The 20% FTE, I don't know that the person doing this has to be an attorney. They have to be at least a paralegal in terms of the way the state sees skill sets in order to be able to really do the assessments, I think, that are part of reporting this information. If I may be so bold, it would be really helpful to hear from Attorney Richter or perhaps Attorney Gagnon on the question of the data collection, because there's a tension between providing us with the information we need to do oversight or analysis and also professional independence of the attorneys. And also in every one of these cases, there's a conflict. And so if I'm collecting the wrong data, there's the potential for a conflict there. And I haven't solved that problem yet.
And thank you for that. Thank you for that. And continue.
Representative Madigan.
Yes, my question is for Justin. When you were talking about what you would need to do a study, you made reference to some sort of measure that would measure well-being or things like that. So you guys don't know kind of what sort of measure that would be. I mean, the Office of Behavioral Health, or, there's lots of ways they use a number of measures, and providers use a number of measures. That would be something you guys would have to figure out, I take it, like what measure you would use.
Yes, I don't have that in mind because at this point, we're dealing with numbers over here in terms of outcome. We have anecdotal stories about people with good results and bad results, but they're not statistically significant. And I don't know even how we get that done. I mean, if we were going to use, there must be some behavioral testing metrics, right? If we're going to do that, we're going to add the cost and requirement that people engage in those tests. And I think that is also a little problematic. I want the information, but I'm not sure how to do it without adding a huge burden. The time in the program may be a reasonable indicator. You have to be careful with it because you want to make sure you don't just have somebody who consented to termination super early and done bad advice and thus has a low outlier. But time in the program is, I think, a reasonable substitute for how long it took to bring stability to the family system. That's not the only thing we care about, because stability the wrong way is bad. But it's a reasonable proxy.
Yeah, I'm just thinking that it's not a bad idea to add a measure in. And there are a number of ones that you don't need to be a professional to administer, and people can take their own. You can do a pre and post test that would probably work out just fine. So
we're working with excuse me, we're working with a program to provide early parent education outside of this by system involved parents who have become social workers, to system involved parents, no attorneys present. And it might be possible, whether they would do it or something analogous, it might be possible to collect the input data in that way, if people were willing to participate in it.
thank you.
Okay, is your hand up again, Representative Stover, or still? Okay, Attorney Richter.
I was just going to follow up on that and say, I think there's a metric of the duration of the department involvement. There's a metric for department filings resulting, and I think you could also do some kind of quantitative survey studies of the participants in this versus kind of, if you have this as a pilot program, you could do it in other regions, and kind of get a sense on how other families are feeling, or how other children are faring in those situations. So the pilot program would give you kind of a base to test from, but yeah, I think that the reduction in the duration of the department's involvement and is going to give you a really nice base. And the other kind of piece is there are federal matching funds under Title 4E that other states have utilized with a memorandum of understanding. And so I think that this would open the door to say, yes, we're giving this, we're piloting this program, but there may be other sources of revenue that are other source of funding for this program that we can pursue. And I think that how it gets implemented might not be completely set, but just the idea that this is the goal, that we're funding this program, I think gives us a starting point to really do some really good work and protect children and to families.
Thank you. Deb Dunlap.
Just a note that in the conversations on the panel, I know that there are other states who have done this, and again, not the content expert, but just noting that through those conversations, that there are other states who have already done this and have demonstrated some success. That would imply that they have evaluation processes, and so it might be worth the committee just taking a look at what other states have done in terms of that evaluation piece, since it seems to be a concern, maybe not reinventing the wheel.
Okay, thank you for that. So are there any other questions, concerns, issues, comments that people want to raise before we move to a motion? Not seeing any, so I will defer to somebody to make a motion. Representative Meyer.
Thank you, Mr. Chair. I move LD 1824 ought to pass as amended.
Second.
Second for Representative Craven. Thank you very much. So the amendments, as I understand them, and Anna will correct me if I'm wrong, are there some language changes that she can work with somebody knowledgeable to square out if they are still standing? And the fiscal note is going to be calculated based on the information we have and whatever else comes out of the conversation. So there will be a fiscal note. Did I leave anything out?
No, I'll need to work with the folks from Indigent Legal Services on the language, and once there's an amendment, then there'll be a fiscal note. It won't come until afterwards, until it's drafted.
Okay.
Because that's how the process works.
Yep. Okay, so that's the motion ought to pass as amended, and those are the amendments. And it's been moved and seconded, so I'll move to Karen for a vote.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
No.
Representative Lemlin, no. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
No.
Representative Connor, no. Representative Griffin.
No.
Representative Griffin, no. Representative Javner.
No.
Representative Javner, no. Senator Moore.
No.
Senator Moore, no. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
And Senator Moore, Representative Javner, minority report.
Ought not to pass.
Thank you.
Mr. Chairman, can I record my vote? I think I might have missed the first LD.
393. The motion was ought to pass as amended. The vote was 7 yay, 5 no, and 1 absent.
Okay, so I would vote yay.
Thank you, sir.
Thank you. You got that, Karen?
I sure do.
Okay, Representative Griffin has made a motion to take a 10-minute break, and I'm seconding it. And why don't we reconvene? We'll make it 12 minutes and reconvene at 12. Thank you for that, Representative Griffin.
Representative Zager, you get the award for being punctual.
Well, not if you average it out over the entire session.
Okay, I won't do that.
Okay, we'll resume the deliberations of our committee and move to item number LD or 850. And I don't know whether Representative Hymanson has joined us or not.
I don't see her yet, but she is aware and is coming.
Okay, great. So we'll have Anna proceed.
Okay. All right. This is another bill that started as one thing and turned into something else. So I will just focus on the amendment. This is Representative Hymanson's bill that takes the funding that is currently provided to the Alternative Response Program contract and applies it to program services for families that remain intact but are involved in a child protective investigation using the intensive care coordination using high fidelity wraparound program. You heard from the sponsor and the proponents about the ARP provided investigation and assessment services of low to moderate risk, and this is being brought in-house, but they also provided intensive case management services for parents to help plan for safety for their children, and there is a concern that there's no plan to replace those services. High fidelity wraparound was part of the state's earlier reform plan, helping to reduce the number of children placed in residential foster care. High fidelity wraparound provides resource navigation for all family members, parent, mentor, support, and flexible funds. And family team meetings are at the core of the approach. There was some discussion about recent funding from the 10% FMAP bump. I don't actually know much about that, and you would need to ask the department because I'm not 100% sure how all of that worked. It's also on the Family First Prevention Services Act approved list. The department said they are currently in the process of implementing a pilot of high fidelity wraparound to children in Maine through the Children's Behavioural Health Services team, an investment of approximately $13 million, and the intent is to consider the service under Maine Care at the conclusion of the pilot. The BLIPI refers to families that remain intact but are involved in a child protective investigations. Investigations are open for 30 days plus 5 days for supervisor approval and closing activities, and the program can't be delivered to fidelity in that short period of time. So the department would welcome opportunities to align resources with need. So that is the drafting issue is OCFS comment about the BLIPI. There was some information about the last round of reforms from the Annie Casey Foundation, provided by Melissa Hackett, and also a 2-page summary that you could click through on the program from the National Wraparound Initiative that came from Deb Dunlap. The fiscal impact applies to the original bill, so I don't know that it's necessary for me to go through all of it, except to say that 3.149 million in general fund beginning in the first year is the amount that was budgeted for the ARP program. Obviously, that was slated to end. So this is ongoing money. So I can bring up the language. Oh, the last thing I almost forgot. There is some discussion around changing that blippy that has been going back and forth. I don't feel like I should personally speak to it, although I'm happy to bring it up at any point. But I do.
Can you, Anna, can you define blippy for the
Oh, I'm
audience?
sorry. It's the initiative language. It's an OFPR term. So it's the provides ongoing funding for intensive care coordination, etc. That language, when you're looking at the amendment, is what the blippy is. So there is some discussion about changing that blippy a little bit. I know that Representative Hymanson and the department have at least been talking about this, and I don't think it's entirely a done deal. So I will stop talking. I'll look for it so I can bring it up if you need it while you are listening to other people.
Okay, so the sponsor for this is Representative Hymanson, and she was able to join us this morning. Good morning, or this afternoon.
Good morning. Good morning, everyone.
Any thoughts about what you just heard from Anna? Anything you want to share about this bill?
Yeah, so the department has been gracious in expanding some of the language, and I have that language. I think I sent it to the chairs, but I can maybe Molly would like to present that. We have one question about one of the phrases in the language you're about to hear, and I'd like to ask about that. Otherwise, it's the people I've been working with through the coalition have accepted the language.
Great, thank you. Molly, you want to jump in?
Thanks, and I'll hand it right to Director Landry. We just want to make sure that high fidelity can be carried out with high fidelity. So he'll provide some context for the language that we've requested.
Very good. Dr. Landry?
Yeah, thank you, Senator. Thank you, Molly, and thank you, Representative Hymanson, for working with us on some language on this bill. We are very much a proponent of high fidelity wraparound and the evidence-based model of high fidelity wraparound. As was indicated, we have put forward as part of our proposal for the use of FMAP funds to implement high fidelity wraparound in the state of Maine, and to do so with Fidelity in partnership with the national model developers of high fidelity wraparound. The language specifically that we have proposed, that hopefully you have a copy of, currently I believe the language refers to families that are involved in a child protective proceeding, and I'm paraphrasing there. Thank you for pulling that up. The language we're proposing, you can see, is in red, so that high fidelity wraparound services provided to families that were identified as part of a child protective investigation. The department shall make reasonable efforts to ensure fidelity to the high fidelity wraparound model, including appropriate referrals, and implement the service to maximize available federal funds, including coordination with other department efforts to implement the model. The reason that we have suggested this language, if this bill is to go forward, is one, based on what we have already shared with the committee, that a 35-day time period is not sufficient to meet the fidelity aspects of implementing the model. So the previous language limited it just to the time period of an investigation, and this language would go beyond that in order to ensure that fidelity. And then the other pieces really are about implementing that service with fidelity and being good stewards of our state resources to maximize available federal funds. So, for example, if a family were referred and they could be captured within the proposed program that we're moving forward using FMAP dollars, then obviously then we can utilize federal funds in order to do that versus only state general funds. And so the language is really designed around identifying and ensuring fidelity to the model. More information is on the Federal Clearinghouse in case you're curious to look at that. but by appropriate referrals, not all children and families would be appropriate based on the model fidelity. And so we would focus, of course, and ensure that the referrals are focused on those populations that the model is demonstrated to best benefit through the program. So that was our intent with the recommended language.
Thank you very much. Any questions, concerns? So mine would be, this fits in well with Family First and is one of the recognized, accepted, encouraged interventions.
It is on the Federal First or Federal 4E Clearinghouse as a promising practice. There are those 3 levels on the Federal Clearinghouse: promising, supported, and well supported. I believe this met the category of promising practice. And so it does have that, for lack of a better term, seal of approval based on the federal review of programs that are shown to get the best results for children and families, particularly those involved or potentially involved in child welfare systems.
And what does this represent in terms of additional cost, depending upon what the federal contribution might be?
It would depend, of course, under the Federal First or Family First authorization, a child would have to meet the candidacy definition. So some families and children would probably meet that candidacy definition and some would not. For those who did meet the candidacy definition, we'd be able to pull in a 50% match. So it's a one-to-one match on those. But I want to be clear, I don't anticipate all families or all children would meet that candidacy definition. So so it's not a direct one-for-one. However, for many of these families, I do believe that they would be eligible to benefit or participate using the FMAP dollars that we have available. And those FMAP dollars are all federal funds.
And in terms of general funds to get to the 50-50 match, do you have a sense of how much new state dollars might be required?
Regrettably, I'm sorry, Senator, I don't have an estimate of how many of these families or children may meet that candidacy definition, and nor do I have a good sense of whether or not all of them that did not meet that definition would be able to be captured in the other FMAP program that the department is implementing. It's too difficult for us to be able to make that type of guess, not knowing the population at this point and specificity.
Thank you. I see we've been joined by Ken Olson. Is this something you want to make a comment about, Ken?
Yeah, I would. I appreciate the opportunity, Senator, to comment on this. I think that this particular bill is particularly important in terms of as it is a follow-up to the ARP program. A little bit about my background and interest here. While I'm currently retired, I have 47 years of experience in working in organizations providing child welfare and children's mental health services. I started my career as a treatment foster parent those many years ago and ended my career as executive director of Kids Peace here in Maine. And for Kids Peace, I also served as the clinical director for our community and foster care programs in 10 different states. So I have a fair amount of experience across the board. And what's important about this bill, I think, is really that it gets at many of the challenges that we have in Maine around access to services and the capacity of providers to meet those needs, particularly in rural parts of the state. And while I'm particularly grateful to the department for expanding the services under Family First, many of those services that we're talking about now involve clinical practice and licensed clinicians, and there is a really well-established shortage of those clinical positions in many parts of the state. I'm thinking particularly down east, Washington County and Aroostook County and some of the western counties where clinicians are a rare commodity. And this is a service that can be delivered as a care coordination service, and therefore would provide an opportunity for services to people who otherwise might not be able to get them. And that, I think, is sort of like the particularly key part of this legislation, is that the need to expand those services that are not necessarily provided by licensed clinicians in areas that are underserved.
Thank you. Any comments or questions related to the analysis, to the, yes, Representative Hymanson.
Thank you. I'm wondering, are all of the, to Director Landry, are all of the qualifying candidates have a behavioral health diagnosis?
To meet Family First, Representative, is that what you're asking?
Yeah, well, to meet this program, which would be under Families First, I understand.
Not all, two parts. Let me try to answer that in two different answers. Not all of those who will have be identified as a candidate under Family First will have a behavioral health need. So no. Some will have a behavioral health need. Some children may not have a behavioral health need. For this program, for high fidelity wraparound, the target population, and I'm just pulling it up here to make sure I say it right, is typically targeted toward children and youth birth to age 21 with emotional, behavioral, and mental health needs and their families. So that's the descriptor that I just read off of the 4E clearinghouse. I will also say to Mr. Olson's comment, he's exactly right. One of the unique aspects that we find about high fidelity wraparound is the care coordinators, as they're sometimes called in this model. Their education requirements are usually determined by the organization implementing the wraparound service. So exactly what he was referring to is one of the other reasons why we've identified this as a good program to implement. Now, oftentimes, if they don't meet certain higher level education requirements, there's an apprenticeship or additional training that's required, but it does certainly have the potential of opening it up to additional practitioners, which I think is what Mr. Olson was referring to.
So legitimately, we can make the case that we're making services more widely geographically available than they are now.
I would say we're making an evidence-based model more available without having to use the highest level of licensed clinical practitioners.
Okay, thank you. Any other points or comments, Representative Hymanson? Any other? Yes, Representative Madigan.
I just want to thank Representative Hymanson for working so hard on this, and high fidelity wrap is something that I've said we needed back for a number of years. So I'm so glad to see this bill. I do believe it will make services available for at-risk families more widely available. And I'm in support of this bill, and I want to thank everyone who worked on it.
Thank you, Representative Madigan. Senator Moore?
I just want to clarify one thing. Thank you, Senator Claxton. Dr. Landry, did you mention that you already have a pilot in place, a pilot project where you are doing this?
That's correct. We announced it. It's not in place yet, but through the FMAP funds available through the relief dollars that came to the state, we proposed as part of our plan to CMS to implement, and I should say to re-implement in some cases in some parts of the state, but to implement high fidelity wraparound in the state. And so that is part of our plan. I believe we have proposed in the plan an estimated $13 million, I believe, to implement high fidelity wraparound through those FMAP funds.
Well, then do we need this bill? I guess that's where I'm confused.
That's a question for the committee, I think, versus me. I would say that it is my belief that families that that may be that would be eligible for to participate in the FMAP pilot or the FMAP program would likely be some of the same families eligible through this avenue, if you will. However, there could be some situations that a family would not be eligible for FMAP, although I can't think of any, and that they would, however, be eligible if they're involved with a child protective investigation. So I don't want to be 100% because I don't think I can be, Senator Moore. I think the vast majority of families who would be eligible through a child protective investigation would also be eligible under the proposed FMAP program, but I can't guarantee you that it would cover 100%.
So we're really just carving out for the child protective, those that are identified as part of a child protective investigation.
That would be my understanding, yes.
Gotcha. Thank you.
Representative Lemelin?
Thank you, Senator. Dr. Landry, I didn't hear you indicate when your pilot program would begin.
We are in the process of developing it. It has to go through CMS or Medicaid approval before we can implement, but our plan is to implement as early as this summer, but it is somewhat contingent upon when we get final approval from CMS.
Thank you.
And if I may, I'm sorry, I would also add that part of the intent of the FMAP program would be that we would then use the learnings from that FMAP pilot or FMAP program, and it would eventually, our intent would be that we would consider it as part of our Medicaid plan so that this service would be Medicaid covered in the future once the FMAP program ended.
Representative Craven.
Thank you, Mr. Chair. I have two questions. Actually, the first one is whether this legislation would piggyback on your pilot program and that you wouldn't have to apply to CMS. And the other part is, what difference does it make that the program would be in statute?
Regarding the first part of the question, yes, we do envision that if this bill were to go forward and pass, that we would dovetail it into the FMAP program, because it would not make sense for us, for example, to do two separate contracts with the national developer of the model. It wouldn't make sense to do two separate trainings. We would consolidate those together. I think that's good efficient use of state resources. As it relates to the statutory aspect of that, I think this primarily is focused, would end up having an impact from a fiscal note perspective, but it also would specifically call out the population that I believe the sponsor, and I of course will let her speak for herself, the population specific that she is focusing on as those families who have had child protective investigation involvement.
Thank you.
Does that match with what you had intended, Representative Hymanson?
Yes, thank you. The purpose is to expand the number of kids into the child protection services.
All right. Are there other questions or concerns, comments? Oh, is that Ken? Are you raising your hand?
Yeah, apparently I can't. Apparently I can't find my raise the hand button on this. I just wanted to make the share the observation that in our experience at Kids Peace with the ARP program, we found that we served many families who otherwise would not have qualified for care coordination services. So I think that's one of the reasons that we think that this legislation is so important, is because it does meet that. It would allow us to continue to serve those kind of folks, and they wouldn't necessarily get ruled out.
Okay, thank you. Is your hand up again, Representative Craven?
It is. If people are ready, I was going to make a motion.
Go ahead.
I would move to pass as amended.
And seconded from Representative Stover. Okay. Any further discussion? Not seeing any. The motion on the floor is ought to pass as amended. The amendment is the fiscal note. And am I leaving anything else, Anna, about some language?
Right, and I'm not sure yet whether that language is actually belongs in the blippy. It might be a little bit of unallocated language when we write language about maximizing available federal funds. We don't usually stick it in the blippy, but if Luke lets me stick it in the blippy, I'll stick it in the blippy. But my understanding, I think, and Molly can correct me if I'm wrong, is that the fiscal note is also likely to change from the amount that was in the original in a way that might make you happy.
Okay, thank you. All right. So motions are made and seconded. It is to ought to pass as amended. I don't see any further discussion, so I'll turn it over to Karen for the vote on LD 1850.
Thank you, Mr. Chair. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
No.
Representative Lemlin, no. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
No.
Representative Connor, no. Representative Griffin.
No.
Representative Griffin, no. Representative Javner.
No.
Representative Javner, no. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
So I have 9 yay and 4 no.
That is what I have too.
It's nice to be voting as a entirely intact committee. That doesn't happen very often, so we should enjoy that. Thank you, Karen. And thank you, Representative Hymanson, for your work to change it from one thing into another. That has gotten some support. We'll see what happens.
Thank you very
Now
much.
it goes, now it goes, now it's in your lap.
Yeah.
Because it's going to be on the table.
Yeah. Thank you.
Okay, thank you for being here. All right, so at this point, we're going to move to consideration of 1853
Oh,
and to do
excuse
so.
me, Senator, do we have a
The
minority report?
Thank you, Karen. Ought not to pass, please.
All right, thank you.
I was doing so well there. I got 2 in a row. Now to move to consideration of LD 1853, I'm going to turn the chair over to Representative Meyer, since it's
Thank
my
you.
bill.
Thank you, Mr. Chair. LD 1853, we'll look to Anna for her analysis.
I didn't do one because I only got this language drafted last night.
So I will look to the bill's sponsor to walk us through that.
It doesn't need any analysis. It's a perfect bill. Anyway, knowing otherwise, this bill is designed to do 2 things. It's designed to make sure that the main Child Welfare Advisory Panel and the Child Death and Serious Injury Panel present reports on a quarterly basis to HHS. If we're in session, they can do that in person. If not, they can do that in writing. And the intent is to have the citizen members, the main resident members, not the department, present these reports as part of an intent to more clearly define and assert HHS's role in oversight of OCFS and the department. That's the intent of Section 2. Section 3 is to continue that oversight and push to have the department, OCFS, regularly report to the committee on basically what are the elements of the Casey family report and the progress they're making in those arenas. That's items 1 through 5. And then it gives the committee related to those reports the responsibility of bringing forth any appropriate legislation. I have a couple of minimal language changes, but that's the intent. I wanted to be able to have the citizen panels that already exist have a role in the oversight process and bringing it to HHS, and that the department would have the opportunity to identify how they were doing with the Casey family recommendations and give us the opportunity to create additional legislation if that was necessary to help them in that work. And to hold them accountable is the overall goal. So that's the basis of the amendment, and I'd be glad to try and answer any questions.
Questions from the committee? Yes, Representative Connor.
Thank you, Madam Chair. Senator Claxton, I just had one quick question. Given that we're starting to we're waiting on the OPEGA report, does this have any conflict with the OPEGA report? Will this put anything into place that they may come back to us and say, we were going to recommend this, or this flies in the face of what we were trying to do? I just want to make sure that there was no conflict there. Have you been working with them at all when drafting this?
I have touched base with OPEGA on a couple of occasions and tried to understand where they might be going, but they haven't released any reports yet. But anything that we pass now that is consistent, I don't think we're doing anything that would step on GOC's toes, because they're not really interested in being an ongoing oversight committee. They just got pulled into that because of the acute need. And this would more clearly put it in the responsibility of the HHS. So I'm not concerned about anything that's harmonious. And if there's something that isn't, then we can look at new legislation to address that.
Okay, thank you very much. I appreciate that.
Sure.
Representative Madigan.
Thank you, Madam Chair. So this basically makes it more clear that the Health and Human Services Committee is the committee of oversight for the Office of Child and Family Services.
That's my intention, and to do so, I tried to create a structure where for the next 2 years, we will be getting quarterly reports at a time when lots of people in our community want to make sure that we're doing everything we can to protect Maine's children.
So the committee, some future members of the committee could also decide based on this at any time, if they wanted those reports to continue, if people continued to have concerns that they would still be able to get that information.
That's the goal.
Okay, thank you.
Thank you. And Representative Stover, who I will remind the committee also serves in the capacity of House Chair for GOC.
Thank you, Madam Chair. And I just wanted to speak as the House Chair of GOC that I would not see this. I see this bill as a complementary process, and it certainly would not interfere with our current OPEGA work or future. Because we're a bipartisan committee that does evaluations and reviews and provides reports upon request. And our work around child protective services has been ongoing for a few years. So we have a very specific statutory responsibility, but it does not and should not have ever replaced the Committee of Jurisdiction, which is the Health and Human Services Committee right here. So thank you.
Thank you, Representative Stover. Quick question from me, Senator Claxton. The reporting from the department is also quarterly, correct?
Yes.
Any,
And
Go
my
ahead.
only language changes would be to make sure it's the citizen members of the panels that report, and that the list of items to be reported on is not limited to. So we'd want to add specific, the specifics that are there, but not limited to that. And then I found it helpful, speaking personally, and I defer to the committee, I found it personally quite helpful to finally get to a conversation that I could begin to understand about primary, secondary, and tertiary prevention. And part of me would like to include the language of that being the format for presentation from the department, speaking to each of those categories and how they're doing in each of those arenas. But that's the committee to include that or not.
so thoughts on the sponsor's recommendation for that friendly amendment? Yes, Representative Javner.
Thank you, Madam Chair. Absolutely, definitely in support of that amendment. That would be very welcome. And thank you, Senator Claxton, for your work on this bill.
Okay. Representative Stover, is your hand still up or is it up again? Thank you.
Looks
Yes,
like
Representative Craven.
She's going to need to move those flowers.
Well, that yellow hand is in those beautiful yellow flowers, so, but I can see her.
Thank you. I should probably know this, but I just wondered if the Citizens Committee was staffed.
Yes, there is a staff member, and they help with the assembly of reports and putting together meeting agendas. It's a person that's currently being replaced because somebody was leaving that position.
Thank you. Representative Connor.
Thank you, Madam Chair. I was just going to make a motion if the conversation was complete.
Go right ahead.
I would move LD 1853 to pass, ought to pass as amended.
I'll second it.
And I've got a second from Representative Griffin. Any discussion from the committee? Seeing none, Karen, the motion on the table is ought to pass as amended. Please run the vote.
Thank you, Representative. Oop. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
Yes.
Representative Connor, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Javner.
Yes.
Representative Javner, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
Yes, Senator.
I was just going to thank the committee for its indulgence in getting this to you late, and to, I'm guilty, and also to acknowledge the significant work that Anna Broom did to get it to this point, and publicly thank her for that. Thank you.
With that, Senator, I'm going to hand the gavel back over to you for the next LD, which is, I believe, 1834.
That was the plan. Thank you very much. So now we can move to consideration of LD 1834. And I will defer to Anna.
Okay, LD 1834. This is an act to establish ongoing monitoring of remains Child Protective Services. The bill requires the Government Oversight Committee to create a system designed to monitor on an ongoing basis the Department of Health and Human Services, OCFS, regarding the effectiveness of the office in protecting the safety of children in state care. The committee may create a working group that has the purpose of monitoring the policies and practices used by the office to maintain the safety of children in state care, reporting to the committee on a quarterly basis, and providing an annual report to the committee and the legislature. So you heard from the sponsor that GOC meets all year round and has subpoena powers, that there is a lack of transparency in OCFS. The bill will require OCFS to report to GOC and HHS on a quarterly basis on the functions of the office, problems and issues, and to deal with the next dire situation. Confidentiality is often used as a reason for not sharing information with the legislature, the press, or the public. And the Child Welfare Ombudsman has raised concerns about the system in her report. Proponents, the lack of transparency and accountability. A work group needs to include all levels of providers, foster parents, caseworkers, supervisors, and management, and caseworkers need more training. And DHHS opposed the concept of a permanent continuous monitoring by GOC. The HHS committee is the designated committee of oversight, including Child Protective Services. OCFS has reported on a regular and ongoing basis to HHS on child welfare issues for the last 2 years, including statutorily required monthly data reports. And OCFS publishes the child welfare data dashboard updated on a monthly basis. And they agree with the OPEGA brief oversight. So there are a number of drafting issues here if you want to move forward. First of all, the working group is optional. If it's formed, then it would report to GOC on a quarterly basis and provide an annual report to the GOC and the legislature. The bill doesn't require a working group or quarterly or annual reports, and the reports don't come from OCFS but from the working group. There's some questions about whether you need more parameters around the working group and need more of a description of what the reports consist of. GOC is required to create a system to monitor OCFS's effectiveness of the office protecting the safety of children in state care. It specifically says state care, so that's only foster kids. That's not all children in contact with the department. And then there's an odd little drafting issue there. Officers defined in that chapter that it's going into as OPEGA, and the bill requires GOC to create a system to monitor DHHS regarding the effectiveness of OPEGA in protecting the safety of children in state care and the policies and practices used by the office to maintain the safety of children. So office is used incorrectly. I think that office is supposed to mean OCFS, but in reality it's drafted to mean OPEGA. And then the question is whether this proposed subsection fits with the duties of the GOC. So that section is evaluating the director and annual work plan, direct program evaluations, auditing services, conduct hearings, etc., etc. It might make more sense if you were going to move forward with this to have it in its own section rather than sticking it at the bottom of the section of duties of GOC. There was a question about, oh, I'm sorry, I forgot to move my thing down. There was a question about oversight system in other states and other kinds of configurations. And luckily for me, OPEGA just did the information brief in January that includes a section on other state approaches about states with ombudsmen. How do you pluralize that? I do not even know. Or the Office of the Child Advocate. You heard about the captive panels. Those are the citizen panels that you just talked about with the last bill. And some have full legislative committees or joint committees dedicated only to child welfare issues. And there's a table in Lucia's report about that. And then the question about what GOC's job is, that wasn't asked by me. So this is the section that describes what OPEGA's job is, what they were created for. And then the section above that we just talked about that establishes the duties of GOC includes reviewing and approving the annual work plan for the office. And I did include, if you were interested in clicking through that, that's the OPEGA outline of what they do, which includes how legislators request investigations and how GOC determines the work plan and so on, which is quite useful if you have never seen it before. So there are some drafting issues here if you wish to move on with move forward with the bill.
Thank you. And I see that Senator Diamond is here, so we'll bring him in and give him a chance to comment. Welcome, Senator.
Good afternoon. Thank you very much.
Good afternoon. So did you hear Anna's analysis? And
I did.
okay. Any thoughts, responses to any of the?
Yeah, I mean, thank you for that, and thanks to Anna for going through those details. The purpose of obviously of the bill was to leave it as open as possible, and to allow the construction of whatever oversight group would be, GOC, HHS. I like the idea of the citizen panels. The whole idea was to just get a structure set up. It looks like the previous bill may have formed out of this in terms of some of the ideas that are using, which I think is helpful. But again, it wasn't designed to be all inclusive in the draft. It was primarily to get the discussion going, come up with some kind of a structure where HHS committee is involved, but OCFS would have an ongoing communication, a two-way communication year-round, which is not the case now. And that's what the whole purpose of it is. I mean, I think there's too many months that go by between April and January, and it really, I think it begs to address the problem that protecting kids is not getting better. It's not even staying the same. It's getting worse, as we've seen in 2021. So that was the whole effort, is to try to find a way to get a communication set up before we leave in April with OCFS and a legislative group that is around and here and has staff and who can address that. Without that, we'll go right back to where we are now. And that is, we'll see everybody in January. And whoever the new people are, I just worry about that length of time where we're not addressing, we're not accessible. OCFS certainly is not accessible, and I think that's a problem.
Thank you, sir. Representative Stover.
Thank you, Mr. Chair, and thank you, Senator Diamond, for this bill. Thank you for your advocacy and your leadership on this issue for as long as I can remember. I think that you've raised for everyone's attention the fact that we do need ongoing oversight. As you know, the Government Oversight Committee continues. It didn't start or reopen an investigation. It never closed the investigation that began with the deaths of Kendall Chick and Marissa Kennedy. And when the additional child deaths occurred in the spring, it was just a continuation of that work. And as you know, we're working in our responsible way as government oversight to provide a bipartisan evaluation and review, and very soon report of our findings. And I think that the bill that was proposed by Senator Claxton, just the previous bill, raises back up that the Health and Human Services Committee has a statutory responsibility as well to provide levels of oversight to OCFS and to all of HHS, in fact. And I think between our efforts, between these two committees, and with the language provided in the previous legislation proposed by Senator Claxton, I think we've got something here. And so I appreciate your bringing this bill, but I think we've got a construct before us that will allow us to do that. But I don't want you to think that I really do hear what you're telling us, and I agree with you that there needs to be that responsible oversight. And I think this committee has had that responsibility, but for a variety of reasons haven't been able to always execute it. So thank you.
You're welcome.
Representative Perry, did you have your hand up?
I did, but Representative Stover actually expressed my feelings.
And just again, in context, I think Senator Diamond, you probably put your bill in in the fall, right?
Yes, that's correct.
And I'm working off a committee bill that was intentionally left vacant so I could steal your best ideas and your intent and some of your passion. I can't match you for your passion, but some of your passion in trying to get HHS to be a reliable oversight committee for this crucial work. And it was for that reason that I also got permission from the presiding officers for HHS to meet in June and September. And at this point, I feel like I have a standing invitation to be on the agenda for GOC on a quarterly basis. I'm headed there Friday to update them on the legislation. So I think there's a changing relationship between HHS and GOC. And that's why I got permission for us to continue to meet at least quarterly to review some of this stuff. And that was taken from your clear intent.
Could I pose a question on 1853? I know you've gone through it all, but it does relate to this.
Sure.
I was just curious, is the citizen panel reports, who are they reporting to?
HHS.
Right now, they're reporting to HHS on a quarterly basis with a defined content, but not limited to only that content.
Okay, so.
And we stipulated that it was the citizens on the panel who were doing the reporting.
Would there be an option, would there be an opportunity for people the public to ask questions when that report is presented? Would it be
That certainly would be my intent as chair, to invite the ombudsman to comment and anybody in the public who wanted to comment or present information. That was my intent, to have an informational hearing.
Thank you.
Yes, Representative Madigan.
Thank you, Mr. Chair. I just wanted to say that I think that HHS has always been the committee that has jurisdiction over this. And I have been really pleased with a number of things that have happened in the past couple of years, including GOC getting involved and GOC being open to HHS members being involved. We've always been informed as far as what GOC is doing. It really feels like it's been a team working on that and doing that oversight. But I do think that that we are the committee of jurisdiction. Due to, I think, the concerns that people in the state have had, we have met in the interim. And I think I feel pretty confident that that will continue to be, as long as people have those concerns. And whenever we've had reports that citizens panels or other groups, give to our committee, members of the public have always had the opportunity to comment on those and to express their opinion about it. So I just want to say that, and I appreciate all you've done, Senator Diamond, around this issue, and your advocacy on it has been amazing. But I think the oversight rests with the Health and Human Services Committee. And I'd like to make a motion ought not to pass.
Before you second to that, Senator Diamond, did you have a comment?
Thank you, Mr. Chair. I just wanted to make it clear, it was never my intent to exclude HHS committee. I understand the jurisdiction and all that goes with that. My basis was, if we have precedent, if you think back to the Maine Turnpike Authority, when the director was accused of stealing $175,000 to $230,000 from the authority, at that time I was a member of the Transportation Committee, and that was not reviewed by the Transportation Committee, even though that was clearly our jurisdiction. It was reviewed by the GOC for a number of reasons, and I think that's how I got to that point. Again, it wasn't to include this committee, but it was to go to a committee that had full-time staff, met year-round, had subpoena powers, and I thought that would be the fairest and direct way. So I didn't want it to be left that I was thinking that HHS should be left out of the whole thing. Certainly it shouldn't. But there is precedent of cases of this review. And in my mind, 30 kids dying last year is equal to or greater than, obviously, than the director of the Turnpike Authority stealing money.
So what I was going to offer too was maybe this bill should be turned into a letter. Would GOC welcome a standing quarterly invitation to HHS chairs and leads or the committee to join them for their hearings? That's directed to you, Representative Silver.
Yes, Senator, we would welcome
And
that.
I think that might address some of Senator Diamond's specific concerns about communication, that if we set that up as a standing invitation and a regular appearance on the agenda, that would give us a chance to hear from another venue in which to hear from interested parties.
I agree, Senator. And also I think to Senator Diamond's point, when we have members of the public, and sometimes those are family members, surviving family members of children, and other professionals that have been involved in child protective cases, I think it's incredibly valuable. And it is the role of government to hear from the public, especially about issues as near and dear to our hearts as this. So thank you.
And we should make sure that presiding officers bless that participation and support it. Okay. Representative Madigan.
I was just going to say, I think sending a letter supporting the continued collaboration between the two committees is a great idea. We should be working together on it. Thank you.
Thank you. Senator Baldacci.
Thank you, Mr. Chair. I also support the letter in terms of improving communication. I want to thank Senator Diamond because I know his heartfelt, passionate advocacy of children is very important and has been very important in this state. And we're going to miss him in terms of being a champion in the Senate, but I know he's still going to be out there and very vocal and keeping us all accountable. I just wanted to indicate that, in terms of this bill, I think it was done last summer when, we were looking for some greater accountability. I'm hopeful that the bills that we're passing, including Senator Claxton's bill, will move us forward and will make some improvements. I personally feel that we may at some point have to revisit the idea of a professional office of Inspector General, such as the state of Nebraska has, and that would be on the job. But I am hopeful that Senator Claxton's bill can move us forward and some other bills that we're considering. But I definitely want to thank Senator Diamond for being a champion who's pretty much led us to where we are. Thank you.
So I heard a motion from Representative Madigan, ought not to pass, and an acceptance of an idea of a letter as the motion to be considered. Was there a second for that?
I'll second.
So that's seconded by Representative Perry. Are there any other considerations, discussions? Not seeing any, then I defer to Karen to collect the vote.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
Yes.
Representative Connor, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Javner.
Yes.
Representative Javner, Yes. Senator Moore,
Yes.
Senator Moore, yes. Representative Meyer,
Yes.
Representative Meyer, yes. Senator Claxton,
Yes.
Senator Claxton, yes.
That's unanimous of those present. Thank you, Senator Diamond. Go ahead.
I just want to thank the committee for all the work you did on this. I appreciate it. Thank you.
Very good. So we've had a yes, Anna.
I'm sorry, I have two questions. One relates to this bill and one relates to the last bill. So the first thing is about the presiding officers blessing the participation from GOC. I will see what I can find out about that. I don't know whether this is about being paid for attending committee. And I don't know what it means for GOC. So I've written myself a little note to find out how that might work before I write that letter. So that's the first and easy one. And the second one relates to the bill you just did, because I didn't know about the June date. And LD 1853 does not have an emergency on it, which means that your first 3-month report will not come by June. So I'm wondering if you want an emergency on it, or you see where I'm going here. I don't know the answer. Okay. Is that good with everybody, just to make sure?
So
I don't think it's necessarily for you to revote, but if you will agree.
Right, how do folks feel about an emergency preamble on 1853? Thumbs up, okay?
So that also
you.
means that I'll be taking out the language about 3 months after the effective date of this act. Actually, not necessarily. Anyway, that's just so if you were really planning on having reports by June, that might actually be possible.
And the reports by June could be by invitation if that doesn't work out. And we could just begin that process then. Okay. So that being said, and having filled up our morning and gone into the afternoon, anybody want to break for lunch? Okay. So 1:40? 1:30, 1:40? Anybody?
1:30. 1:30 sounds good. We have a full afternoon.
Quick lunch. It's 2 more bills to go. Okay, 1:30 it is. We'll see everybody then. So it looks like we're back and gathered just after 1:30. Thank you all. So Anna, if you're ready, we'll move to the consideration of LD 1825 and then do 1866. And then we can move to the public hearing.
Okay, hopefully you are looking at 1825.
Not yet.
No, oh, okay.
There
Well,
we go.
oh, I just took it down. Now you're confusing me. You aren't really looking at it, are you?
Not now.
Oh,
We were
okay.
there briefly. We were
Okay.
briefly.
Okay.
We were briefly.
All right. So you are again, right?
It says you've started screen sharing there. Don't touch anything else.
Okay. All right. Sorry about that. It must just take longer than I think. All right. 1825 is an act to establish limits on the number of hours worked by and workloads of Child Protective Service caseworkers in the Department of Health and Human Services. The bill requires that the department ensure that a caseworker in OCFS does not work or drive more than 60 hours over 7 consecutive days or 70 hours over 8 consecutive days. A caseworker may be required to work for up to 14 hours following 10 consecutive hours off, but may not drive for more than 11 hours during that shift. Caseworkers must maintain a driving log while working, and maximum workloads must consider factors that influence time required, including the number of children in the family, the level of interaction needed, child's placement, geographic spread, and driving requirements. It repeals Resolve 2019, Chapter 34, which required the department to develop a caseload recommendation with the public consulting group. This bill requires the department to report to the Health and Human Services Committee and the Child Welfare Ombudsman whenever a caseworker's workload exceeds the maximum workload. The Resolve Chapter 34 directed the department to report annually until 2030 on its standard caseload recommendations. This bill instead requires the department to submit to the Health and Human Services Committee an initial report with findings and recommendations in October of 2022 and annual reports in January 2023 and after on the staffing, caseload, and workload assignments of caseworkers by county and district office. So you heard from during the testimony from the sponsor and the MSCA that this is a safety and worker retention issue, two things, safety and worker retention issue. And the demands on caseworkers are overwhelming. You heard from MSW students and caseworkers that the OCFS workload report, there's a current need for 33 caseworkers. KC said there was a high turnover rate, so it was one of the factors contributing to increased fatalities, and that self-care for the caseworker is impossible. And you could have units in every county to reduce travel, increase in positions, and legal representation assigned earlier. Those were things that they recommended. You heard from the department that a statutory charge to ensure the health and safety of children who are abused and or neglected or at risk. There's a limitation on hours a caseworker could work and drive could jeopardize the ability to fulfill that statutory charge and create additional duplicative work for staff. There is a budget initiative to hire additional staff for dedicated after hours and weekends coverage. There is no universally accepted caseload or workload standards, and because it depends on the work they're doing. And OCFS has devoted resources to establishing the workload analytic tool with reviews and reports, and driving logs are onerous. There's a couple of drafting issues, I think. This establishes a maximum workload for a caseworker, which takes into account different factors. It's not entirely clear to me whether this is a single maximum workload or different maximum workloads for caseworkers. So I don't really know the answer to that question. And then the requirement to report to the HHS committee and the Child Welfare Ombudsman when the maximum workload has been exceeded by a caseworker. Is that every time that happens? How soon after? And what if the legislature is not in session? And what does the the committee and the Child Welfare Ombudsman do with that report? Maybe you don't want to worry about that, but they do seem questions that seem a little obvious to me, that if you get that report, what happens then? And is that every single time? And then that should have said additional information. I'm sorry, not requested by the committee. So I just wanted to remind you of the result that is being repealed in here. This is the one to develop the standard caseload recommendations and report annually, and you for 10 years, and you've received 2 of those reports. And Dr. Landry presented the most recent report at the time that he came and presented a whole bunch of reports. And then there is also just the budget proposal, which is on, I can bring it up if you need to see it, on page A105, which is 16 caseworker positions, 3 supervisors and 1 public service manager. My understanding is those are the weekend and overnight folks. And we haven't yet received anything from OFPR. The other thing I did just want to show you, because I think it's easier to see than to read about it, is I just wanted to remind you of, this is what the resolve looked like that is being repealed. This is the one with the 10 years of reporting. So it has a hot link in the bill analysis, but that's what it looks like. And I believe this was a Colleen Madigan bill as well. So that's all I have for you.
Thank you. Thank you. So Representative Madigan, any comments, thoughts?
Yes, my intention is not to repeal the 2019 law. This bill is really about work hours. So I'm fine with stripping out mileage logs and things like that. And I think I'm fine with keeping in the language just about the maximum hours worked. This is really about making sure that caseworkers and case aides that may be transporting children, that it's absolutely safe, that if it's unsafe for truck drivers or any of us to work 16 hours and then get behind the wheel of a car, then I think we need to say that that's the same for child protective caseworkers. So I guess my question would be to Anna, we can strip out the mileage language.
If that's what you want to do. I'm not sure that not repeal, I'm going to have too many negatives here if I'm not careful. The Resolve 2019 Chapter 34, I do think if you're going forward with the bill, you have to repeal this, because there is a certain amount of sort of conflict here. I mean, aside from anything else, you're telling the department in statute to establish a maximum workload. So there's no real need to have those other reports coming in. I mean, that's why that would have been repealed in this bill. I was just reminding people of what had gone before.
Right. What I was thinking, it was more maximum hours.
And that would have nothing to do with workloads or caseloads, right?
But that's not true, because paragraph D says the department shall establish a maximum workload for a caseworker. I don't think that's hours. The hours are in paragraph A, and then, or in B, I guess. Paragraph C is the one about the driving log that you would remove, but paragraph D is establishing a maximum workload. And that's my question about what does that even, what does that mean? Are you saying that you'd strip out that as well and keep the old resolve? I guess that's what you were saying, and I just wasn't quite catching.
Yeah, keep the old resolve, strip out the mileage logs, and then just the maximum hours. What I'm trying to prevent is people working, multiple shifts and doing overnight hoteling or overnight emergency coverage and transporting children. I think the work the department is doing as far as workload analysis and things we still have to hear about.
So if you are stripping out paragraph D, that also affects the whole of section 2. The section 2 is the part about the department reporting when maximum workload established by that paragraph is exceeded by a caseworker, they would report to you. So that whole thing would go away. Is that what you're saying?
I think that's fine. It's the maximum hours that this bill's really about. It's really the maximum hours and the the hours off between next worked. Does that make sense?
I think I understand what you're looking for.
Okay.
And there was also the question of who gets reported to when legislature's not in session. Did you have a?
She just took it out, the whole thing.
Okay, good. All right. And, okay, good. All right. Representative Zager?
Muted.
I'm not hearing you, sir.
Thank you, Mr. Chair. I think that the issue the department raised about the potential conflict with the statutory requirement to look after the interests of the child is an important one, but certainly not insurmountable. And it kind of, I mean, I feel like we have an obligation certainly for the interests of the children, but also, fairness to workers and safety for workers. And so I'm wondering if the committee might consider if the sponsor might consider some sort of friendly amendment to have some sort of allowance for an emergency or an acute circumstance that where there's clearly a need for the child has some sort of need, and in order to meet that need, they would need to work overtime essentially, so that the department and the case workers who are doing this difficult work are not caught between two statutory requirements, but that they can serve the needs in the acute situation, but that the overall picture is one that is safe, and that has these work hour limitations.
I would support that. I mean, I think I have no desire to delay the time that a child protective worker needs to respond to an emergency. And certainly if there's a need for that in an emergency situation, allowing the department to do that and working with the worker as far as, how best then to meet the hours and all that is fine with me.
Okay. So looking at the bill, you're striking 4C and D. And 5, section 2.
And section 3.
Hadn't gotten to that yet. And section 3, okay. Which is the repeal, right? Okay. Yes, Representative Meyer.
So thank you, Mr. Chair. So given what's been struck, exactly where are we? What are we left with?
The way I understand it, we're left with section 1, paragraph number 4, staffing, where it describes 60 hours over 7 days and 70 hours over 8 days as the maximum, and may work up to 14 hours following 10 consecutive hours of not working, but may not require a caseworker to drive for more than 11 hours during that shift. That's what's left from the bill. And then we just had the conversation with Representative Zager, as I understand it, about creating an exception
Yeah.
in exigent circumstances.
That's my understanding of it as well.
Okay, good. Senator Moore.
Thank you, Senator Claxton. I guess I have another question in my mind. Are these caseworkers part of the Maine Service Employees Association and covered under a union contract?
Yes.
Madigan?
Yes.
They are. Okay. Then I guess my question would be: is that are we circumventing the labor negotiations that should go on? I mean, that these setting hours like that to me should be something that would be in a union contract.
I've never been a union negotiator myself. Don't plan on it.
It's not fun, let me tell you.
I didn't see this as a union negotiation thing so much as in some ways existing language that exists regarding safety, regarding driving hours, which we're going to consider work hours just because every time a caseworker works, they have the potential to drive a child in the custody of us. These are the same driving hours that essentially exist for truck drivers. So in other words, and so I didn't see that as a union negotiation issue so much as a safety issue that already exists.
I guess I was just thinking when you start talking about hours and the limitations, it falls in line almost like your vacation times and time off and different things like that. So that's why I was asking that question, because I think it could be handled in the union negotiation as opposed to us putting it into statute. I guess that would be my comment.
Representative Zager.
Thank you, Mr. Chair. I think Senator Moore raises a good point, but I guess I would see this kind of like how the federal government and through the FAA and other mechanisms has requirements, limitations for what pilots can do and turnaround times for air crews, and as a matter of safety, even though they also have representation through their airline unions.
Thank you, Representative Jadner.
Thank you, Senator Claxton. Can we please hear from the department what their policy is right now on the books for their driving, specifically for the driving hours?
I'll defer to Director Landry. Do you want to take that, or do you want Molly to?
Either one of us, I think, can take it. I'll go ahead and jump in. Thank you, Senator. As it relates to this topic, certainly what is being described here is exactly the process that we follow. The number of hours, there are certainly situations where overtime is required for the reasons I believe that Representative Zager was alluding to. Absent those emergency situations, then no, we're not requiring staff to work those kind of hours that are listed out in the bill, and that does include driving hours. So we look at it as collectively on those totals, not necessarily separated out. I will point out, and it's already been mentioned, but certainly we understand, appreciate, and acknowledge the aspect of the impact of standby and overtime coverage on staff. We've heard that from staff directly, and we have responded to that in the governor's budget proposal, specifically to add these positions. The positions that we have proposed, the 16 caseworker positions and the 3 supervisor positions, are specifically designed and are committed to establishing those standby and overtime positions to avoid the situations that our staff are telling us that sometimes interfere most with their work-life balance and their ability to meet the other requirements of their positions.
Does that answer your question?
Yes, thank you very much.
Representative Lemelin.
Thank you, Senator. Director Landry just answered my question. My concern was the staffing, and he says he's already in the middle of hiring new staffing. So after hearing Dr. Landry, I guess I fully oppose this bill because it seems to me that he's already in the process of taking care of all the matters that this bill is saying, that we have a problem, but Director Landry's indicating to me that he's trying to resolve that.
I agree with the last part of that. What I heard was that it's in the budget proposal to hire these folks that would cover this, and therefore doesn't fully exist yet. Do I understand that right, Dr. Landry?
That is correct, Senator Claxton. It's included in the governor's budget proposal, which this committee, I believe, will be hearing in work session tomorrow and Thursday. So we certainly hope that the that this committee and the full legislature is going to endorse the governor's budget proposal to add those positions to specifically address this specific topic. And so, Representative Limelin, you're exactly right. It's intended to address this specific challenge, but no, we haven't put this into place yet because the legislature, of course, has not had an opportunity to authorize that.
And are there work hour restrictions now for the caseworkers? And how do they line up with the ones that are in this bill?
There are no, to my knowledge, and I need to go back and look at the labor agreement to be absolutely clear about that, because Senator Moore is correct. There are some pieces in the labor agreement. I don't believe there are very specific limitations. There are, of course, overtime provisions, et cetera. And so I'd have to go back and look. I don't believe there are specific ones, but certainly our intent and our practice is to only require overtime in situations where there is a standby overtime emergency situation that needs to be immediately addressed, which is why, in part, because of the feedback from our staff and what they shared with us, we have proposed to the governor's budget initiative to address that with these additional positions.
Thank you. Are there other questions? Concerns, points to be made? Yes, Representative Madigan.
I guess I would just like to ask Director Landry how many vacancies there are today.
We currently have about a 10% vacancy rate among caseworkers. For all of child welfare staff in total, I believe the percentage is around a 7% vacancy rate. So we have about a 10% vacancy rate right now within the caseworker lines. I would also say that one of the other things that I'm most pleased about with the budget initiative is by adding the additional lines, it potentially would avoid any of the unintended consequences that we had discussed in our testimony about the possibility of staff having to duplicate work or have to have this conflict that some of you have pointed out from a statutory duty perspective.
Thank you.
Very good. Any other questions? That being the case, I would entertain a motion. Or not. We need some sort of motion. Yes, Representative Zager.
Thank you, Mr. Chair. I move ought to pass as amended, with the amendment being the allowance for some emergencies or acute settings.
Plus the striking of parts of
Plus
section
striking,
1,
yeah.
all of section 2, and all of section 3.
Yes, sir.
Yeah.
And I would second that.
So it's been moved and seconded, moved by Representative Zager and seconded by Representative Stover. Is there additional discussion, questions?
Does somebody need to decide who would decide when there's an exception? I mean, you're setting up a sort of an inherent possible conflict in the law, and I don't know who would determine that, or what would happen if somebody was told that this is an emergency setting. Who would they appeal to if they didn't think it was? I'm a little confused about how to. Maybe I'm overthinking it, but I'm a little confused.
Representative Madigan, and then we'll go to Molly.
I would imagine those emergencies would be responding to an immediate removal. You know, and when a child's safety is at risk.
But who would determine it? Not the what, but the who.
Oh, do we have that kind of stuff in statute?
It just seems to me that there's no process, that you're just saying if there's an exception, who decides if there's an exception? Maybe, like I said, maybe I'm overthinking it, but it seems to me that it's not clear then who's deciding and what happens if the caseworker doesn't really agree. I don't know. Like I said, maybe I'm overthinking it, and you can ignore me, but those are the questions that spring to my mind, and I don't know. Maybe Molly will tell me I'm completely up the creek without a paddle, and that's okay too.
That might be covered and might be answered by rulemaking, but let's hear from Molly.
I would never tell Anna she was up a creek without a paddle. But I do, she asked the same question that I was going to ask, which is just some clarity around what that exception could look like. I mean, you know, I think largely we try to adhere to reasonable work hours, you know, except for in these emergencies already. And so if there's an expectation that this is going to be different than the way, you know, hours are currently managed, I think it needs to be clear, and who has that discretion would be helpful to us. I mean, obviously, you know, it could be the supervisor, it could be someone in leadership at OCFS, but I think that needs to be clear. So thank you.
Representative Perry?
I'm processing, so give me a moment here. What I see is that we're trying to do with this bill is to create a safety guideline, so that if somebody has worked 70 to 80 hours a week for the last 5 weeks, and then they get called even more to transport a child, it's a safety issue. It's so I think that's what Colleen is trying to put together. It's really about a safety issue. Now, the other thing to work with, and I think this is where the difficulty is, if you have a caseworker who almost once a week gets an exceptional order, I would say that's an overuse of it, because at that point, and I think this is what some of the caseworkers dealt with, is that they were so tired when they had to do this. They had to spend 24 hours, you know, with a child, and yet had their other cases to work, and had no way to get leeway in terms of how they're doing it. My concerns are safety, driving safety. The other safety piece of it, you have a person, and they did this when they did studies on interns who were working 24 hours a day or doing 2 days, is that you get so tired, your reactions are that of an inebriated person, which means your thought processes are slow, everything else is not working as well either. So what have we created then is we've created a caseworker who is literally ineffectively thinking, ineffectively follow through. So, you know, I think it's a conundrum. It really is a conundrum, but I think that I guess I'm looking at this as a safety issue, and how do we define that and put that together? I don't think I have a great way of saying that, but I think that we have a system that is not working well. We have people that are saying they're working so tired now that they're not doing well. And I think it is a good idea to create some guidelines for safety's sake. And I think that does belong, not in negotiations, but I think it does belong with either the department creating a safety issue or it coming from the legislature. That's my my convoluted thinking, but that's where I am on that one.
Thank you, Representative Perry. Representative Madigan.
Yeah, I want to thank Representative Perry for saying that. And I also want to thank the department for all the work they've done. And this is in no way meant to denigrate the work you've done. This bill really is about safety, and it's getting at it in the way that, you know, okay, we don't want caseworkers driving if they're too tired. But Representative Perry kind of started to go there. And this was my thought in crafting this, is that when you look at the problems we've had in child welfare, what we found is there were cases we can go back to the Kendall Chick and Marissa Kennedy case if we want, but they were at some point open to child protective services and things weren't followed up on. When workers work too many hours and they're too tired, things get dropped. And in no way do I think it is fair to blame that on workers. And I'm not saying anyone is, but in no way do I think that's fair to blame that on workers if they're working under these conditions. And so we have to maintain that it's not just the safety of children potentially being driven by cars. It's also the safety of children and of families, all of which may be touched by the system. And that was my intention with this bill. I think it's fine to put, as far as if we need something in statute, as Anna has suggested, that who makes that decision. I think it's fine if a supervisor in consultation with OCFS leadership make that decision as far as what's an emergency. I'm fine with putting that in there. But I do think there need to be some guardrails because this is one of the toughest jobs in state government. Frankly, I've never done it, but I've worked with a ton of them. It's really hard and it is heartbreaking. For those of us that sit on this committee or those of us that have seen the news for the past few years, I don't need to tell you that. And I want to make sure everything I've said, seen and researched over the years is the best way we can improve the system is to make it responsive to the children and families that it serves. And giving workers the tools and the support to do that is one of the best ways to make that happen.
So does that give you enough language to work with, Anna, talking about supervisors in consultation with leadership?
I guess so. You may want some rulemaking as well. I'm not really sure.
I didn't hear that last part.
Sorry, I didn't know if maybe you needed some rulemaking to go along with that. I'm not really sure, but
Certainly sounds
sure,
to me,
that is certainly the who.
Yeah, that sounds to me like there's a role for rulemaking in there. Dr. Landry?
Yeah, I simply wanted to take an opportunity to thank Representative Madigan. I certainly don't disagree what she has said. I simply, certainly it's my thought and my belief that the best way to handle this issue is through the budget initiative that we have put forward. That's going to add the positions that we think are necessary to cover these emergency overnight weekend situations, restore more work balance to our existing caseworkers, enable them to complete the tasks and the duties that they have. And it's my position that that's the best way to approach this issue as opposed to what this bill has proposed. The overall, I do want to though just emphasize the overall goal that we're both after here, and all of us, I believe, are looking for is the exact same.
Can I ask Dr. Landry, so if it's in the budget and it doesn't pass or it gets taken out, then having this language in would still provide some guardrails?
Well, my concern at that point would be we have guardrails and then we don't have potentially the staff in order to ensure that we don't exceed those guardrails. I think that's when we're going to have the potential unintended consequence of a situation where we have a statutory obligation for the safety of children. And at the same time, we have a guardrail that says that worker needs to, in fact, potentially leave that role or have another worker come in order to duplicate some of the work. Now, granted, the language that we're currently, that's being contemplated, we haven't seen, and we could certainly take a look at that language. I just want to make sure that we're not setting ourselves up for an unintended consequence of either duplicative work of our staff or the risk that none of us want to take, which is potentially putting a child in harm's way.
Mm-hmm. Thank you. Representative Zager?
Thank you, Mr. Chair. I'm wondering if, with respecting the time, if we might do a brief corner caucus so that we might be able to figure something out and discuss this. So I would wonder if you and the committee would support a 5-minute corner caucus.
Before we do that, let's go to Representative Perry. Did you have your hand up for?
I did. think that it would be important that Dr. Landry have an opportunity to see the exact wording of the proposed, what is coming up proposed wise. I'm wondering if there's a way we could ask Anna to put that together with an opportunity for Dr. Landry to see, and we revisit this bill with our next work session.
So that's two different directions. Do anybody feel, either of you feel strongly about that? We've had plenty of time to work it out if we put it off to another work session, which may be into next week. So did you want to make that?
I would just want to indicate, Mr. Chairman, I would support Representative Perry's request.
So that was a motion, Representative Perry, to table?
Yeah, I guess it was. Yes.
And it's been seconded by Senator Baldacci. All those in favor of tabling until our next work session, that we can get it in and the wording gets done. Okay, that's unanimous of those present. Okay, so you have a several days corner caucus opportunity, Representative Zager, at the earliest. All right. Let's go to consideration of 1866. And we'll bring in the sponsor.
Can you see 1866?
We can.
Okay. Okay. So this is an act to ensure low-income families and children with special needs can access after-school services. The bill requires the Department of Health and Human Services to reimburse for after-school services to children enrolled in the main care program. The department must reimburse for after-school services, whether the services are provided by a licensed childcare provider, an after-school program operated by a school district, or community recreational program, in the same manner as services that are medically necessary to access education at school are reimbursed. If services are provided to a child with a disability in an after-school program, the department must ensure that the services are appropriate to the child's need, and any additional staffing necessary to provide those services must also be reimbursed. The bill also provides that a child eligible for main care services is also eligible for childcare subsidies, and those subsidies may be used for after-school services, whether the provider is a licensed childcare provider, an after-school program operated by a school district, or a community recreational program. So you heard from the sponsor and the proponents that the bill would expand the scope of programs that main care covers. Subsidies can be used for childcare, which is more expensive, but not for recreational or after-school programs. A few recreational programs provide assistance for special needs at their own expense, and services are available at school for special needs don't continue after school. The workday is longer than the workday, and the bill could be expanded to include vacation and summer camps. You heard from Disability Rights Maine and Maine Med that there are legal requirements for children with disabilities to access extracurricular activities and equal opportunities to participate in after-school programs, including reasonable accommodations. And there is a lack of after-school programming of any kind for children with disabilities. You heard from I always forget what that analogy, that acronym is, the MAEYC, the Education of Young Children folks. The special education services for children birth to age 4 are served by CDS in child care settings. School age kids are served by the local school district. Services end when the school day ends, and there are billing issues for childcare programs in school districts. You also heard from the department that the funding structure and requirements in the bill are not allowable under federal regulations. Medicaid only pays for medical services, and after-school services are generally not medical. The subsidy program, that's the CCSP, is funded primarily by the Child Care Development Block Grant, which provides eligibility guidelines that don't align with eligibility requirements for main care. There are sort of multiple pieces in this proposed legislation that involve different funding sources. The Medicaid for after school, the services provided at school that are medically necessary that are also in after-school programs. The main care eligibility also means subsidy eligible, and that subsidies must be accepted in after-school programs. The childcare subsidy requirements pieces, it probably should be in that section of Title 22 rather than Medicaid. It's just a little confusing, all shoved in the same place. Not the sponsor's fault, my fault actually, because I drafted it. I did send you some links to look at if you wanted, but I also know that you received a memo from Molly, and so maybe you want to hear about that next. I could also bring that up if you need, Molly.
So looks like I'm having trouble finding the sponsor. But Molly, do you want to go ahead and present what you have?
She's here.
There she is. I found her. Molly, do you want to go ahead and present, or do you want us to go to the sponsor first?
You can certainly go to the sponsor and we can answer any questions that you have after that. Thank you.
Okay, thank you. Representative Granlund, welcome.
Thank you, Senator Claxton and Representative Meyer, and thank you for your deference, Molly. I am Lori Gramlich, and I represent House District 13, which is the community of Old Orchard Beach. So I had done a fair amount of work on this particular piece of legislation, and it is somewhat cumbersome when we kind of overlay everything with the Medicaid program. Just a couple of points of clarification. In terms of families being eligible for childcare subsidies to use a voucher to pay for aftercare programming, one does not need to be receiving Medicaid in order to receive a voucher or a subsidy. There are different income eligibility criteria that families need to adhere with, and the providers need to also meet some eligibility criteria. Generally speaking, if a family is a recipient of Medicaid, they would likely meet those income eligibility criteria. So that's one piece. The other piece of this has to do with children with disabilities being able to access aftercare programming, i.e. rec departments, and being able to use their subsidy. I did a bit of work with folks out of Washington with the Administration of Children and Families, and got some clarity around that particular piece of the requirements. And the information that I had received out of Washington, I had received from the administrator of Region 1 for the Administration of Children and Families, and from also the manager of the Office of Child Care Region 1, Shireen Riley, and then the administrator is Elaine Zimmerman. And the information that they had shared with me was that Medicaid will indeed reimburse for a covered service, and a covered service does not necessarily need to be reflected in the child's IEP in order for Medicaid reimbursement to be available. Now, they went on to elaborate that some states do still have language in their Medicaid state plans that limit Medicaid reimbursement of services in a school setting to those articulated in their IEP. However, they are receptive that if a state is interested in amending their state plan, they can provide technical assistance on how to do that. They did share with me that there are a number of states that have approved that in their state plan. Now, in terms of a child subsidy, in terms of the provider, the family fills out an application to identify that they have met the eligibility criteria. Additionally, as I referenced earlier, the provider also has to meet some certain criteria. It is my understanding, based on the conversations that I've had up to this point, that in order for a licensed exempt provider to meet that criteria after applying, they have a whole list of requirements that they need to adhere with, many of which recreation programs are currently doing. The difference is that if they want to be recognized as a licensed exempt provider, they have to indicate that they have had 6 hours of training for health and safety standards. That is available online to providers, and it is free to them. They also have to have background checks done. They do that as part of their rec program anyway. But I will note that to become a licensed exempt provider, the background checks are paid for by the state. The other additional item that they currently don't do in order to become a licensed exempt provider would be to have fingerprinting done. And again, that is paid for by the state. As I mentioned, currently recreation programs must be in compliance with health safety, including first aid, CPR. They have to be in compliance with the state fire marshal's office, physical plant requirements, et cetera, et cetera. The training piece that they would have to do that they're currently not doing, but the training piece that they would have to do to become a licensed exempt provider includes training around infant care. So one of the things I would like the committee to consider is for the training requirement for providers to become licensed exempt providers would be to extract the infant care training from that and keep the training very specific to school-aged children. Finally, let me see, I just want to make sure I'm not missing anything for you. So yeah, I've got some proposed amendment ideas that I would like the committee to consider. One is to address the training piece. The other, and I'm not sure exactly how to do this, but it seems like there's a bit of a disconnect between what the providers are hearing and what they're doing. That many that I have interfaced with are under the impression that they the requirements are too laborious for them to undertake. And what I've been able to uncover is that it's actually not that much different from what they're already doing. So it's rather surprising to me that we currently only have about 7 municipalities that meet the requirement for licensed exempt providers. It would be wonderful to be able to pave the way so that we could get more folks, more providers to meet that criteria. I mean, you are all well aware of the fact that we are at a real shortage of childcare providers, and so it's a challenge and a struggle for many, many families throughout the state of Maine. So it would be wonderful to be able to pave this way for families. And again, I just want the other amended piece I would ask for the committee to consider is to assure that licensed exempt providers are able to receive subsidies for children with disabilities, regardless of whether or not their IEP notes that they need that kind of care and support. So I'm mindful that I've been talking a bit, and I'll stop now and happy to try to answer any questions.
Okay. So I guess first I need to be clear about what the bill is at this point. Is that the 3 things you just offered?
Yes, Senator. Anna and I went back and forth a bit when we originally, were talking about crafting the language, and it might have very well been, my misinformation in terms of the eligibility criteria for families in order to receive a subsidy. One does not need to be a recipient of Medicaid to be able to receive a child care voucher subsidy. So there's that piece of it. And I see Molly is nodding her head on that. So there's that piece we would definitely want to correct in the language of the bill. Furthermore, I think there's a disconnect between what I think the state's very clear, but I think somewhere something got lost in translation in terms of what the providers understand. And I think that is evidenced by the fact that we have so few providers taking advantage of this opportunity. So I think we need to, in some way, shape, or form, try to address that. I don't have a hard and fast answer for how to do that, but it seems like there could be a chance to get more folks to meet this license exempt criteria.
Okay, so thank you for that clarity. So from the department, can we run through those 3 things? So are we a place where you can get services without an IEP?
So I would need to get clarity from Maine Care on that. I do want to just remind the committee that we're in the process of establishing Section 106, which is Maine Care rules for school-based services. And so I know that work has been happening in partnership with the Department of Education, and I apologize, I haven't spent quite as much time on the IEP side of this bill with Representative Gramlich as we've spent on the child subsidy piece, or child care subsidy piece. But I do, it's certainly true that you can receive child care subsidy without being a Maine Care recipient, whether currently in our state plan amendment, you can, I don't believe that we support school-based services that are not medically necessary for the receipt of education services. And so if a service is not identified as on the IEP, or if a service is not determined to be medically necessary for that child to receive their education, then I don't believe that there's Medicaid, coverage for that service currently. But that is where certainly the child care subsidy could come into play if the family is eligible for that. I don't know if Director Landry has additional information to offer there.
Please jump in.
Thank you, Senator. I would say that Molly's exactly right. From a child care subsidy perspective, so not Medicaid, but child care subsidy perspective, in order to receive the additional payment related to, you want to make sure I use the right term here, regarding special needs or for children of disabilities with disabilities, an IEP is not required. You do have to have some type of physician documentation, but it does not have to be in the IEP in order to qualify for that additional reimbursement for children with disabilities on the subsidy program.
Okay. Any thoughts in the department about barriers to license exempt provider status? It sounds like you've provided the online training, the free background and fingerprint. How come there are not more of them out there?
I think there are a few different reasons that we've been told. I think as our memo indicated, there are 22 programs in 10 different jurisdictions or areas that currently are either license exempt or fully licensed. I believe that's in the memo that we provided to the committee. As far as why others do not, we've heard different things. Some have indicated to us that through other funding mechanisms, they have scholarships or other subsidy type programs that they use instead of the child care subsidy program. So they're able to accomplish, from their view, the same support for families without the subsidy program. We've also heard from others that have more of a philosophical belief that sometimes that may play into it. Certainly, that's not very many, but we've heard from a couple that believe that. So I'm not sure if I can answer or speak for all of them. I can tell you, of course, that we have a number of programs that have done that, and we continue to work with any of them that are interested in doing that. And my appreciation to Representative Gramlich for pointing out all of the ways that the state attempts to support that, including providing, virtually all of this at no cost to the providers or to the REC programs. And I think, as she heard from our regional federal authorities, that's a bit unusual versus other states which don't provide those at no cost and as readily accessible as we do here in Maine. So thank you, Representative Gramlich, for pointing that out.
So what would you really like to do with this bill at this point, Representative Gramlich? What needs to be accomplished that isn't in place?
Well, it was at the end of your question, Senator. Sorry, I thought you were.
Yeah, no, that was the end of my question. There was a question mark there.
Okay, thank you. I think as I identified, and again, I'll just reiterate, in terms of the training that, and again, Dr. Landry is right, and I did, confer with the feds on this. Maine is very generous in terms of how they try to accommodate providers, not only with the training, but with background checks and fingerprinting in terms of cost to get rid of that kind of a barrier. But one of the pieces of feedback that I did receive for school-aged children and for school-age programming, it doesn't seem to make sense to have training that has to do with napping and diapering and SIDS and a lot of different components relative to infant care, for example. So I think that certainly needs to be addressed. Additionally, and again, I'm not sure exactly how to do this. I mean, I know Dr. Landry referenced it. I think it's a very small portion of folks that he was identifying in terms of the reasons why they're not taking advantage of this. I don't know if there's an opportunity to do some better outreach or education to folks to help them understand that it isn't as cumbersome as they think. Many of the providers that I have spoken with are under the impression that it is a rather laborious undertaking to meet the license exempt status. So that's another piece. And then finally, I'd like to be able to figure out a way to assure that license exempt providers are able to receive subsidy for children with disabilities, regardless of whether their IEP notes it. And again, this is information that I received directly from the feds in terms of the Medicaid reimbursement program for children with disabilities.
Okay, as the last point, what I heard was that kids with special needs and disabilities, but no IEP, are still able to get subsidy.
That's my understanding from Ms. Zimmerman out of Region 1, the administrator for Region 1. The family would still have to apply for the subsidy, but there's a place on the form where they would indicate whether or not they had a disability. And again, that would be through the Medicaid rules. And I'm not sure where things are in the state of Maine relative to what Medicaid's doing, but my understanding from the federal government is that the states are given a bit of latitude in terms of how they can modify their state plan to try to accommodate this particular population.
So the question is, does Maine need to do anything to make it more accessible than it already is with that background? Dr. Landry?
Kind of where I've landed.
I think there are two different pieces here, if I may, Senator Claxton.
Please.
I think one piece is related to subsidy. I don't think there's any question related to the subsidy piece about whether or not an IEP is required. It is not. I think it's a different question as it relates to Medicaid eligibility for Medicaid coverage of school-based services. In that case, it's a medical necessity requirement. And I would defer to Director Probert, unless Molly already knows this answer on how that is perceived. So there's two different funding mechanisms, if you will. One is through the Medicaid side for medically necessary services. The other one is a subsidy piece for children with disabilities. The subsidy piece, there's no question, the IEP is not required, but I can't speak for Medicaid as far as it relates to medical necessity and how that's determined for school-based services through Medicaid.
Yeah, but that's determined by CMS largely, right?
Generally, depending upon the state plan, but I think what Representative Gramlich is pointing out, states have the opportunity to potentially amend their state plan depending upon how it's worded and what CMS approves.
So Molly, do you want to weigh in on whether Medicaid coverage for medically necessary interventions helps with after school?
Sure. So I think that the medically necessary is the crux, and I will just add the caveat that I'm currently going back and forth with Maine Care on one screen and speaking to you, and so may need to provide some additional information in a follow-up. But Maine Care contends that under federal CMS, we cannot pay for childcare or custodial care with Maine Care dollars. That is different, certainly, than after school care that includes behavioral health or other components that make it a Maine Care service. And so I think that's where our definitions are perhaps overlapping or lacking some clarity here. But if it is the rec program, for example, a rec program as consumed by children who aren't receiving medically administered services through Maine Care, then Maine Care cannot provide payment for those services. But the services that are Maine Care services can be delivered as aftercare in these settings, as long as they're those medically necessary services. I'm seeing Senator Claxton's face and thinking I just confused everybody, but
No. I get the concept of medically necessary. I also understand that it's Medicaid and CMS that determine that and not us. We can't lobby for them to change their definition.
yeah, I think there are options within the state plan, but if it is childcare, without additional services,
Right.
teen care cannot cover that.
If the kid's getting PT or behavioral health help, then that's a covered service likely. And if they're not, then there's no way it's going to get covered.
Right. Although, that's again where I think childcare subsidy comes in and fills that need for.
Yeah. No, I meant not covered by Medicaid. I should have finished the sentence. Right. Okay.
Right.
So then the other 2 points were, I don't know how to help diminish the barriers for the license exempt providers. You've done a lot of making that accessible to folks. So I don't know what else the department can do. And as I heard the other piece, Representative Gramlich would like to shrink the training program from 6 hours to exclude those items that are not related to, or exclude those items that are related to infants and toddlers. Is that what I'm hearing?
Yeah, that's what I heard.
Okay. All right. So how does the department feel about, yes, Director Landry?
Regarding the training piece, I just pulled up Federal 45 CFR Part 98, which governs the lead agencies for child care subsidy. I'd be happy to share this with you. There are very specifically, I believe it's 10 requirements that the training must include, and that is their language, it must include. And one of those pieces is prevention of sudden infant death syndrome and use of safe sleeping practices. So that is specifically in 45 CFSR Part 98, and I can read you the rest of the pieces of the act. We can certainly talk again to our regional authorities to see whether or not they have the ability to waive certain pieces of that. But as I'm reading 45 CFR Part 98, it would appear that that would be an absolute requirement based on federal CCDF rules.
So you don't think we should go against the CFR?
The last administration did that, and we ended up with a penalty or a potential penalty that we spent a good chunk of our first 18 months here in my role obviating. So I would prefer not to go back into a penalty situation with CCDF.
Okay. So Representative Gramlich, how about a letter to the CMS asking if we can reduce the training in these circumstances and encouraging the department to continue outreach?
Absolutely. And again, I am getting this information. What I literally did when I sent the chairs my notes this morning was literally cut and paste from the email I got from Ms. Zimmerman. So okay. I'm feeling like there's a little bit of a disconnect somewhere here. I respect and understand that it's a very complicated system and we're dealing with several moving parts, but I'm left with feeling that there's a disconnect. So anything that we can do to kind of bridge that, I am completely all for. And again, I just want to underscore that, and I know I'm being redundant, but I'll say it again. My intent with this legislation is to assure that all children, regardless of their circumstance and their ability to pay and their ability and disability, have the opportunity to access aftercare programming of their choosing.
And okay. So at this point, I'm not sure it sounds like there's anything we can legislate that would assure where you want to go with that bill, unless I'm missing something. So I'm wondering if we couldn't have you partner with the department in a letter to CMS and examining of the current rules and regs to see if there is an opportunity to do some legislation that would make it more universally acceptable. Would that be all right in the form of a letter to the department?
I'd be happy to partner with the department, and I would encourage, I would be happy to have another conversation with our contacts in Region 1 with the feds along with the department so that we can all hear the same thing at the same time. Because as I said, I feel there is a bit of a disconnect.
Okay. But in the absence of that, there really isn't anything we can do legislatively, it seems to me, to move the needle. It's you and the department working together. It sounds like the next logical step. Are you comfortable with that next step, Molly?
I am. I regret that we're left in some confusion here because I don't think we're saying anything different from the feds around subsidy and Medicaid supported aftercare. But definitely, we've had a lot of really good conversations about this and more than happy to continue those.
Okay. And you can get that clarity about that understanding. Any other points, questions, concerns? Representative Stover.
I don't want to belabor this, but I just wanted to clarify, we're talking about after-school programming, not infants, right? Because we got into some stuff about infants. I want to make sure we're not talking about infants, right?
After school, we're not talking about infants.
Thank
That's
you.
part of the problem with the training. It includes too much information about those damn infants. I mean, about those infants. Okay. Representative Javner.
Thank you, Senator Claxton. I'd like to make a motion, please. Move ought not to pass on LD 1866.
Second.
Can we add a letter to go to the department and Lori about working together?
Is that considered a friendly amendment, Representative Javner?
Absolutely.
Okay, so the motion is ought not to pass with a letter to the department about continuing work to clarify these, any unresolved issues. All right. Any other discussion? Yes, Molly.
At the risk of perhaps putting Representative Gramlich, I guess, in a position she doesn't want to be in, we could certainly commit here on mic and save the analyst team some drafting time by saying that we commit to the committee to working together. And I don't know if you need to send a letter to the department and Representative Gramlich to tell us to do that. Friendly amendment to your friendly amendment, perhaps.
I don't know either, but Anna will explain it to us shortly. Do we need a letter, Anna?
You're really asking the wrong person. You decide that, but Molly's right. You're sending a letter to tell them to do what you're telling her to do right now. And she's right here.
Maybe
Okay.
we don't need a letter.
Yeah.
I hear what you're saying and I accept that.
All right. So we don't need a letter then.
I am willing to work with the department and
Okay.
other vested stakeholders to assure that we can have families, particularly kids with disabilities, being able to take advantage of rec programs. That
Okay.
I'm committed to that.
So Representative Javner, are you okay with removing the letter from as a friendly amendment?
Yes.
Okay. So the motion on the floor is ought not to pass. I don't see any other discussion. I will turn to Karen to collect the vote on LD 1866.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes. Yes.
Representative Craven, yes. Representative Connor.
Yes.
Representative Connor, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Javner.
Yes.
Representative Javner, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
Unanimous of those present. Thank you, folks. Thank you, Representative Gramlich, for for your concern for kids and after-hours programs.
Thank you.
All right, at this point, I'm going to turn the chair over to Representative Meyer so we can get to the last item on our agenda for the day. Thank you, Dr. Landry, for your help, and you, Molly, for clarifications.
And thank you, Mr. Chair. With that, I will open up a public hearing on LD 2007 and invite you to introduce this piece of legislation.
Thank you, Madam Chair. I'm pleased to introduce LD 2007, an act to create the amyotrophic lateral sclerosis incidence registry. This is a bill that I'm submitting at the request of the governor. For those of you who haven't been listening, I'm Ned Claxton, and I'm honored to serve Senate District 20, which includes Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. This bill is a proposal to set up a registry for a condition called amyotrophic lateral sclerosis, also known more easily as ALS, but also as Lou Gehrig's disease. And it's a very uncommon condition. And there's maybe 50 to 80 people in the state who have it. But there's recently been some significant progress in research and some glimmers of hope for treatment. And this bill proposes to put together a registry that would make those with this diagnosis be available for involvement in research protocols should they choose. There's adequate, this will become a reportable condition and fit in with the CDC's data collection and their attention to rare diseases. The hope is that by aggregating these folks, they could at least be informed of the opportunity to participate in research should they want to. And I know research like that is going on at Mayo and Mass General and places like that. And often they're looking for participants as they get ready for, as they try and build studies. So ALS can be inherited, but it's in a very small percentage of people, 5 to 10% of the total population. Mostly it's sporadic and nobody knows exactly why it comes up, but it seems to be some sort of interface between environmental issues and genes, and maybe including things like exposures, such that there are significantly higher incidence of ALS in veterans. So there's some question about what they might have been exposed to that would make them vulnerable. We are required in the state, our providers are, to report on 27 other conditions. This would add another non-infectious disease condition to be reported. And the goal is to promote research and development of better approaches to therapy for a condition for which we have relatively little to offer in terms of therapy. And so with that in mind, I encourage you to support the concept of an advisory, of a registry. And we can join large parts of the rest of the United States in a national registry or regional registries in terms of sharing this information. So thank you for that.
Thank you, Senator. Questions for Senator Claxton? Seeing none, this is a, yes, Representative Sager.
Thank you, Madam Chair. Senator Claxton, are there, I mean, I think it's vitally important to do the things that you've outlined. Are registries that are not in statute, though. I know like certain blood cancers have international registries and databases, and so what can you shed some light as to why a legislative fix is the best way to go?
This would make it a mandated reportable disease. and therefore increase the likelihood of collection, as opposed to volunteer registries, which is what the other ones you're talking about are. And this would be more consistent in collecting the names of the family of the individuals and families who are impacted by this disease, and make them more readily available for research as opposed to a volunteer registry.
Okay, thank you.
And answer your question, Sam?
Yes, it does. Thank you, ma'am.
Representative Connor.
Thank you, Madam Chair. Senator Claxton, as the subject matter expert, are there any downsides to a registry? And if there are, can you just tell us anything about them? I don't see any, but again, I don't know the industry. So if you could shed some light.
I'm not aware of any downsides. You would be automatically entered into the registry as the patient. Your participation beyond that would be entirely at your discretion. And your medical data is confidential, as it is for the other umpteen diseases that have to be reported. This is not a public database. It's a researcher would have to ask, can I access the database to identify potential people for my study? And they would have to be approved through a mechanism that's involved with rulemaking, would involve some rulemaking.
Excellent.
Senator Baldacci.
Thank you, Madam Chair. I would just ask, is this something that we could move into a work session now on, or
You know what, Senator, we've got, this is a governor's bill, and we've got quite a bit of testimony behind Senator Claxton, including Beth Bosang from the governor's office and Maine CDC.
Okay, I will withdraw the request. Thank you.
Sure thing. Representative Craven?
Thank you, Madam Chair. So if it was a national registry, how would we require, how would Maine require them to oversee that for us?
We wouldn't require the National Registry to oversee it. We could agree to make our data available so that the National Registry could tap it if they wanted to.
Oh, thanks.
Yeah, we're not dictating to the National Registry.
Thank you. So I would invite Bethany Bosang from the governor's office. Welcome.
Good afternoon. Thanks so much. I know the committee's had a long day already, but there's a lot of people who've been really eager to testify before you this afternoon. So we deeply appreciate the committee's patience and listening to us on this bill. So good afternoon, Senator Claxton, Representative Meyer, and members of the Joint Standing Committee on Health and Human Services. I'm Bethany Bosang, Senior Policy Advisor to Governor Janet Mills. I'm here to testify in support of the governor's bill, LD 2007, an act to create the Amyotrophic Lateral Sclerosis Incidence Registry. The governor thanks Senator Claxton and Representative Osher for co-sponsoring this important legislation. Amyotrophic lateral sclerosis, or ALS, is a progressive and fatal neuromuscular disease with no known cure. It is characterized by a degeneration of motor nerve cells in the brain and spinal cord, leading to muscle weakness. As it progresses, ALS can result in the inability to speak, swallow, walk, and to paralysis. Yet for most of those with ALS, their minds and senses remain. The cause of ALS is unknown. Evidence concerning risk factors relating to heredity, genetics, injuries, and environmental exposures are all being researched. But what we do know about ALS is its devastating effect on those diagnosed with the disease, as well as on those who love them. Just over a year ago, we lost Maine sportsman and author George Smith, who passed away after a 4-year battle with ALS. Joe Mayo, longtime state legislator and clerk of the Maine House of Representatives, died of ALS in 2002. Chris Smith, a Maine artist, wood craftsman, sailor, and landscape business owner, also died just over a year ago of ALS. These are 3 individuals among countless others who we have lost to this disease. You will hear more about them, as well as others today, from family members, physicians, and others who will testify or have written to express support for LD 2007. This bill would require that healthcare practitioners and facilities report diagnoses of ALS to the Maine Center for Disease Control and Prevention in the Department of Health and Human Services in order to create and maintain a statewide registry for surveillance of ALS. It requires the Maine CDC to then report annually on the statewide prevalence and incidence estimates of ALS, including any trends occurring over time across the state. This bill was modeled on Maine's successful cancer registry and informed by Massachusetts' existing ALS registry. While there is a national ALS registry created by Congress and launched in 2010, it is incomplete as it relies on data submitted on a voluntary basis by patients. Having mandatory reported of Maine-based data is essential to achieving the goals of assisting patients and their families who are seeking additional information about the disease, as well as researchers who are seeking information about risk factors and potential causes of ALS. The governor strongly supports LD 2007 and urges its passage in support of those living with ALS, in honor of those we have lost to ALS, and in the hope that research ultimately leads us to the cure and prevention of the disease. Thank you for your time and attention. We look forward to working with you on this proposal, and I'd be happy to answer any questions you may have now or at the work session.
Thank you. Questions for Ms. Bosang? Seeing none, we would welcome Representative Lori Osher, who is a co-sponsor. Welcome, Lori. Welcome.
Thank you. Good morning, Senator Claxton, Representative Meyer, and esteemed members of the Joint Standing Committee on Health and Human Services. I'm Lori Osher. I represent House District 123. That's the majority of Orono's residents. I'm here today to testify in support of LD 2007, an act to create the amyotrophic lateral sclerosis incidence registry as the bill's lead co-sponsor. The purpose of an ALS registry is data collection, and good data is essential to tackling vexing scientific problems. As some of you know, in addition to my role as a legislator, I'm a scientist. More than 2 decades of my career were spent as a research scientist. I worked at several institutions, including North Carolina State University, the University of California, Berkeley, EPA's National Exposure Research Lab in Athens, Georgia, and for 9 years, I was a research and teaching faculty member at the University of Maine. In all of my research, data was important. I support the creation of an ALS registry because it will help track the prevalence of ALS in Maine and the frequency of new cases. Public health officials can use that information to compare Maine's rates to those found in other places, to check trends over time, and to identify geographic patterns of ALS across the state. The data in the registry can be used by epidemiologists to investigate potential causes of ALS. Outreach to people listed in the registry can broaden the conversations that will advance the research for treatments. Connecting data on ALS in Maine will form a foundation of knowledge that will benefit the health of Maine citizens. In addition to providing data, the ALS registry would be designed to protect patient privacy. I have heard about many ALS cases in my district alone. The suffering and deaths are heartbreaking. It was also heartbreaking to learn that there is no central database of ALS sufferers for Maine, so there's no way to know whether the numbers of people with ALS in my district and across Maine are increasing or decreasing or static, or if they occur in clusters. This registry will provide data to answer these questions. Maine needs an ALS registry, and I appreciate the opportunity to speak in support of this bill that calls to create it.
Thank you for being here this afternoon. Questions for Representative Osher? I'm seeing none. We'll hear next from Gordon Smith. Gordon, welcome.
Good afternoon. Just coming on here. I'm Gordon Smith from East Winthrop. I'm testifying today on my personal capacity. Very emotional. So you'll have to bear with us. I really stand by the testimony that my sister Edie prepared. She is a constituent of Representative Griffin, and as many of you know, works on the staff of Senator King, so she couldn't be with us today. So I'm happy to just call your attention to our written testimony. While the disease is rare, which is a good thing, it's also devastating. And during our journey, I was surprised, frankly, to learn how little the work in research had advanced. Actually, you'll remember that it was the former Boston College player who did the Ice Bucket Challenge that probably put more money into the research and assistance with this. I know you'll hear today from the foundation, and they do an amazing job to help people struggling with this disease. But you know, a registry is a pretty simple thing to ask for, and George did reach out to a lot of people who he heard from one way or another had the illness, but again, it would have been, there needs to be more advocacy for people struggling with this disease. Another piece of it is that so many people get diagnosed very late. George was very lucky. Joe Mayo was quite lucky, but in that respect. But again, I really appreciate the governor putting in the bill and Senator Claxton. And I will leave it at that. Answer any questions you have.
Thank you, Gordon, for being here today.
Yeah.
Questions for Gordon Smith? I'm seeing none. I'll move to Maine CDC's Kim Hagan, please. Welcome. There you are.
Good afternoon.
Good afternoon.
Senator Claxton, Representative Meyer, and members of the Joint Standing Committee on Health and Human Services. My name is Kim Hagan, and I serve as the state registrar. I'm here today to provide testimony on behalf of the Maine CDC in support of LD 2007, an act to create a amyotrophic lateral sclerosis incident registry, which is a governor's bill. LD 2007 requires healthcare providers and healthcare facilities to report diagnosis of amyotrophic lateral sclerosis, ALS, to the Department of Health and Human Services for the Maine CDC to create and maintain a statewide registry for surveillance of the disease in the state. The bill provides confidentiality protections regarding information that directly or indirectly identifies individuals. Many people know ALS as Lou Gehrig's disease, named after a famous baseball player who was stricken with ALS and forced to retire from baseball. ALS is a degenerative disease that causes nerve cells to stop working and die. This leads to muscle weakness, paralysis, and eventually death. Life expectancy is 1.5 to 4 years from the onset. It is currently projected that the prevalence is 4 to 6 people in 100,000 that are living with the disease at any given time. It is unclear what causes most cases of ALS, although a relationship between genetic background, occupation, and environmental factors are thought to play a major role. Many environmental factors that are thought to increase the risk include the use of herbicides, exposure to environmental pollutions, heavy metals, and a neurotoxin produced by blue-green algae. There is little information about how many people in Maine are diagnosed or living with the disease. The goals of creating a registry are to collect data that can be used to estimate the number of new cases of ALS that will be found each year, gain a better understanding of who gets ALS and what factors affect this disease. The information will be used to improve how the disease is managed and how standards of care are developed. Maine CDC strongly supports this bill so that we may gain a better understanding of the disease and inform epidemiologic studies on the causes of ALS. The data will be helpful in evaluating trends over time and in identifying geographic and demographic patterns. Thank you for your consideration of this matter and the opportunity to provide testimony today. I'm happy to answer any questions from the committee. I would be available to participate in the work session. Thank you.
Thank you. Questions for Ms. Hagan? Seeing none, we'll go to David Doan. Welcome. Go ahead, your mic is off. You can begin. Welcome. It's back. You're muted once again. Try it one more time. There you go. Welcome.
Welcome. Thank you. Thank you very much. Good afternoon, committee members. Thank you for the opportunity to present and support Bill LD 2007, an act to create the amyotrophic lateral sclerosis incident registry. My name is David Doan, and I live in Bucksport, Maine. I'm a person with ALS. ALS is a rare fatal disease. The incidence of ALS is approximately 2 per 100,000. There is no cure and only 2 approved medications that can slow the progression of the disease. Almost 50% of those diagnosed with ALS die in the first 2 years after diagnosis, with 90% dying within 5 years. ALS is a cruel, insidious disease, taking away your ability to walk, talk, eat, and breathe. About 10% of the cases are familiar, meaning genetic. With the remaining cases, the origin is undetermined, known as sporadic. Veterans are 3 times as likely to be stricken with ALS, and Gulf War veterans have been reported to be 10 times more likely to be stricken with this fatal disease. All cases of ALS are different, some impacting a patient's ability to eat and speak at first, while others are impacted by limited use of their hands and feet. And all ALS progression is different. ALS is always fatal. I'm here today in support of the bill to make sure that every Mainer stricken with this deadly disease is counted and appropriate funds, therapies, and services are provided to those living in Maine. There is a national registry. However, there's a problem. There's no required reporting by healthcare providers. It's self-reported. So imagine this, you've just been told you have 2 years to live, get your affairs in order. Where does reporting to a registry fall on your to-do list? Pretty far at the bottom, I think. So why is the ALS registry important? To provide correct counting of all ALS patients in Maine to assure that services, technology, and maybe therapies could improve the extent of life is made available to these patients. Maine has a small interdisciplinary clinic in Brunswick. Unfortunately, it does not provide Mainers with access to new technologies, research, or clinical trials, or expanded access. To obtain these services, you must travel to Boston, an option not available to many ALS patients due to disease progression and limitations. Correct reporting of ALS patients should assure appropriate services are now provided to Maine. To provide valuable research data and help identify clusters. Clusters are areas of higher than normal incidence that may be due to environmental factors. This act does not create a burden on healthcare providers with significant additional costs or expense, yet its product yields valuable data. Today's current electronic health records make reporting of this disease very simple. Since the population of Maine is aged, it is anticipated that the incidence of ALS will increase, as does the age of Maine's population. And lastly, it creates and maintains additional awareness of ALS. I am one of the luckiest patients with ALS. My progression is slow, and I have the ability and access to services and therapies from the greatest ALS research center in the world. That's Massachusetts General. But because of my relatively strong health, I am currently living without a tracheostomy, without a respirator, without a feeding tube. It is my responsibility to speak for those who cannot. Please provide all ALS patients the opportunity for hope by supporting an act to create the ALS Incident Registry. Thank you.
Thank you for being here today. Questions for Mr. Dillon? Seeing none. We'll move next to Karen Tilburg. Welcome, Karen.
Thank you. Senator Claxton, Representative Meyer, and esteemed members of the Committee on Health and Human Services. My name is Karen Tilburg. I live in Orono, Maine. And I want to express my deepest appreciation to Governor Mills for introducing this bill, and to Senator Claxton and Representative Osher for being lead sponsors. My husband, William Christopher Smith, died from ALS about a year ago. And I had approached Governor Mills' office about that time to explore establishing such a registry for the reasons that have been so eloquently laid before you. My husband was 68 years old. Here's a picture of him. I don't know if you can see it. He's wearing a t-shirt that says, "Never give up." And he was strong, vibrant, talented artist, wood craftsman, ran a successful landscaping business, and had been a merchant marine. We first noticed that Chris was slurring his words. What was the cause of this, we wondered. Then he became deeply fatigued, and that was very unusual for him. He began to have trouble swallowing and was choking when he would eat and try to drink at meals. We were eventually connected to Dr. Elijah Stommel at Dartmouth Hitchcock, who was able to make the diagnosis of ALS. He gave Chris 2 years to live, and Chris died about 2 years to the day of his diagnosis. Soon, Chris had to have a feeding tube inserted into his stomach to be able to eat because he could no longer swallow. He had trouble swallowing his saliva, and so he had to take medications to dry out his saliva. He was drooling. Then he lost all his ability to speak, and he had to write all his thoughts on a whiteboard, on paper, or on the computer. In time, he could no longer safely use his woodworking tools. Then he couldn't walk. He had a breathing assist device, a cough assist device, and a nebulizer that he relied on to breathe, make his breathing easier. The saddest loss for me was his ability to smile as the muscles in his face no longer worked. There was loss after loss after loss. And as you've heard, there is no cure for ALS. There are brilliant people dedicating their careers to trying to find a solution, to try to understand the causes. But the researchers don't know where the demographics are of this disease. They just don't, imagine trying to, as a researcher, figure out where everyone is or where there might be clusters or demographic and other basic patterns and trends. This can be addressed with LD 2007, and I want to thank the CDC for working to move forward based on some wonderful experience with the Massachusetts registry. It does respect privacy, and it is working there. I want to just recognize that Chris was a fighter, and he gave every ounce of his energy until the very end. When he was diagnosed, he asked me, "Karen, are you up for this?" We journeyed together in this frightening, terrifying, frankly, new reality until the end. It was an honor to be by his side, but I do not want others to either experience this disease or as a family member or loved one to lose their loved one to this disease. It is brutal and there is no exit. Thank you for voting ought to pass on this legislation to help accelerate a solution to ALS. I'd be happy to answer any questions.
Thank you, Karen, for being here today and sharing Chris's story with us and for your advocacy. Thank you. Questions for Ms. Tilburg? Seeing none. Welcome, Lori McFerrin. Good afternoon.
I'm Lori McFerrin, the Care Services Coordinator with the ALS Association. I'm from Saco, Maine. I'd like to speak on behalf of the National ALS Association and our support for LD 2007 for creating an ALS registry in the state of Maine. We are grateful to the governor for submitting this bill, to Senator Claxton and Representative Osher for bringing the bill forward, to Karen Tilburg, who truly has been the fuel behind this bill, and to our friend George Smith for his work with Karen in the initial stages. I have submitted a full written testimony and will refer you all to that information for a background on ALS, as well as the ALS Association. I think knowing what we do is really important, but I'll reference you to my written testimony. Today, I want to use the valuable time we have to speak in support of the state ALS registry. I think in order to highlight the importance of the state registry, I need to speak to some of what the National Registry does but can't do. A bill was created in 2008 for the National ALS Registry and Biorepository. The registry currently receives $10 million in federal funding and is administered at the Centers for Disease Control and Prevention. It includes data from existing national databases such as Medicare and the VA, as well as information provided by persons with ALS who, as David said, choose to or have the time to participate. The registry also funds 21 academic institutions to identify, examine, and evaluate potential risk factors for ALS. These grants are focused on environmental exposures such as heavy metals and persistent organic pollutants, genetics, identification of biomarkers, and potential occupational exposures. It also funds selected state and metropolitan area ALS surveillance projects because of concerns that data on minority groups might be missing from the National ALS Registry. Lastly, the registry includes a biorepository that collects various tissues from people living with ALS and postmortem collections. However, the National ALS Registry has not been able to provide data that can be used by researchers on a state-by-state basis. This is because of federal regulations preventing release of state-specific data, patient privacy regulations, which we can all understand, and ALS's status currently as a non-reportable, non-notifiable disease. Others have mentioned that there has been some success in other states with state registries. Massachusetts is one we've become rather familiar with. In 2002, Massachusetts was one of 7 states awarded funds by the U.S. Centers for Disease Control and Prevention to track health conditions thought to be impacted by environment. Today, that registry collects patient demographics, clinical symptoms and laboratory data, diagnosis, and treatment. All of the Massachusetts documents are available on the Bureau of Environmental Health website. A little bit about who we're serving here in Maine. Our chapter has served over 250 families in Maine in the last 5 years. someone earlier said we might have 50 to 80 folks at any particular time. We don't really know without a registry. And I know that I typically am working with over, somewhere between 65 and 80 families at any given time. And that's only through referral. I know that our chapter is not serving all of those who are in rural areas, in areas where there isn't a neurologist helping them access supports needed. I'd like to suggest that having the registry will help us provide better education to practitioners who ultimately want to help their patients. And that should lead to better resources for the families living with ALS. Across the state, physician education and training is needed. The disease itself is complex and multifaceted. Lack of ALS education really equates to a lack of access to appropriate care in those regions that don't have ample neurology or ALS knowledgeable providers. I want to again thank you all for your time and your attention to an ALS registry. I believe for Mainers, it's a step toward improved access to appropriate care and a cure for those living with ALS. Thank you.
Thank you, Ms. McFerrin. Questions from the committee? Seeing none, I have one. What triggers addition to the Maine registry for a Maine resident who is diagnosed and treating out of state?
Let me see if I'm understanding your question. If a patient is being seen, as David said, he gets his treatment in Massachusetts, how might that land on our on a state registry?
Yes.
I honestly can't answer that. I'm thinking that it is included, and I just am not knowledgeable. So if there's a good means for me to be able to get that information to you, I'm really happy to do that.
Sure. Thank you. Seeing no other questions, appreciate your being here today. And we will move to Sarah Calder. Welcome.
Good afternoon, Representative Meyer, Senator Claxton, and members of the committee. I'm Sarah Calder. I'm the Director of Government Affairs at Maine Health, and I'm here to testify in support of LD 2007. Maine Health is dedicated to improving the health of our patients and communities by providing high quality, affordable care. We educate tomorrow's caregivers, and importantly, by researching better ways to provide care. And this work, as some of you may know, is coordinated by the Maine Medical Center Research Institute, or MMCRI. Research is central to our mission, and it's with that said that we strongly believe that robust data collection on disease incidence contributes to finding life-saving cures and prevention strategies, as you've heard today. And so it's for that reason that we support this legislation, which creates an ALS registry, and that will be similar to that of cancer and other infectious diseases. We would urge the committee, however, if you move forward with this legislation, to ask the department to implement the registry in accordance with the National ALS Registry, so that Maine contributes its information to the National Registry and supports national research efforts. I would also mention that we do believe there are federal and private funds available to establish disease incidence registries, and would ask the department, and I'm sure they're well aware of it, to seek those funding opportunities. And then would just finally ask that the department reach out to Maine providers who treat ALS patients, like the clinic at Midcoast Parkview Health, or ALS researchers like MMCRI, as it works to create the registry. And thank you for your time today. I'm happy to answer any questions that you may have.
Thank you, Sarah. Questions for Ms. Calder? Seeing none. Is there anyone in the attendees that would like to provide? Dan Moran has his hand up. I'm assuming Dan wants to provide testimony on 2007. Karen?
He's on his way.
And here he is. Welcome, Mr. Moran.
Afternoon, Representative Meyer, Senator Claxton, members of the committee. My name is Dan Moran. I'm the Director of Government Affairs and Communications for the Maine Medical Association. We're situated in Manchester. I reside in Gorham, and I was born and raised in District 59 in Lewiston. The Maine Medical Association is here to submit testimony in support of LD 2007. I won't go over the points that have already been made that are contained in our testimony, other than a couple key points. 90% of ALS cases have no genetic explanation, which is one of the main reasons why our members decided to put strong support on this bill. You've heard about the ALS National Registry and some of its holes, and I'll touch on that a little bit. We wanted to especially relay to the committee, with Maine's history and ongoing experience with PFAS and PCBs and fish and shellfish, which is contained in our testimony, we shouldn't downplay or dismiss environmental health hazards on the long-term health of Maine people, especially with such uncertainty with the causes of ALS. You have testimony, it's not from us, but in doing research for our testimony and talking to some members, Dr. Elijah Stommel, a preeminent national neurologist from Dartmouth-Hitchcock, looks to have submitted written testimony. So I would advise you to take a look at that. He and his research colleagues have found some interesting data on a potential connection between ALS and some of that blue-green algae we all see appear in some of the lakes each year. The National Registry, you've heard, it's voluntary. It comes from some Medicare and veterans claims. Because of the holes in data, I want to bring to the attention of the committee something that hasn't been brought up yet. The estimates of ALS cases are too low, and due to that limited data, we can safely assume that the National Registry is more likely to undercount people from underserved communities and minoritized populations. And that was one of the focus of MMA's core priority platform for the 130th legislature, was to take a look at some of that healthcare inequity that exists. Massachusetts law actually specifically directs specific data to be obtained from urban, low, and median income communities and minority communities of the Commonwealth. I have a link to that statute in my testimony. It's also important to know that ALS incidence increases with age up to 75 years and in the older population, especially with Maine's demographics. I think that's why it's that much more important that we have a registry here. The longer a population is exposed to harmful environmental factors, especially our rural populations with long histories of exposure to agricultural toxicants. And let's not forget the rich history of the mills in Lewiston, Auburn, and Biddeford-Saco, despite well-documented waste discharges from the pulp and paper mills. I was born and raised a little less than a mile and a half, probably more, a little over a mile from Maine's third longest river, the Androscoggin, in Lewiston. And I always used to remember my dad and mom saying, "Do not go near the river." And my dad actually used to reference some old guy that used to live in town, who used to say, he was a farmer, and he used to say the river was too thick to paddle and too thin to plow. That's how bad the river was with the discharge. Who knows if that had any effect on the local community? And I'll finish with, I have a personal story also. One of my Lewiston high school friends, his name was Dave Lafayette. He died at the young age of 39 years old back in 2007 of ALS. I don't think I've ever met a nicer guy. He always had a smile on his face. He operated a successful website to promote awareness and provide research. And believe it or not, that website was once recognized as one of the most frequently visited ALS websites in North America. It's important that we get this data. It'll be helpful to evaluate trends in the incidence and prevalence of ALS in Maine and to identify potential geographic and demographic patterns. Thanks for allowing us to testify. Maine's physicians are in strong support of LD 2007, and we want to thank the governor for putting forward this bill, and of course, Senator Claxton for sponsoring it.
Thank you, Dan. Questions for Mr. Moran? Seeing none, I'll ask one more time to the attendees. Is there anyone who would like to provide testimony in favor, opposed, or neither for nor against that is in the attendees? I am seeing no hands up. That would conclude the testimony on 2007. Questions, comments from the committee? Representative Perry.
My question is, would it be possible, I don't remember how we do the motion,
to go into work session for this bill.
I am going to take that as a motion.
I would second it.
Okay. And I think we can do a show of hands. All in favor of moving into work session? It looks like it is unanimous of all those present. So I would open the work session on 2007. It's all yours, Sam.
Are you able to hear me?
We are.
Okay, thank you. I'm in a different spot than usual today. So I don't have a written bill analysis for this, but I did review the bill this morning, and I don't see any legal issues with it. The only question that I had was more of a policy question, which hopefully one of the folks here for the public hearing can answer, and that was related to Representative Meyer's question. Was to make sure that there was a way to include folks who might have been diagnosed and receive therapeutic services entirely out of state. I don't know how prevalent a situation that is, but just wanted to make sure that the language wasn't missing anybody accidentally for the registry.
It looks like Molly has opened her window. I know we still have Kim Hagan from Maine CDC here. Did you want us to bring Kim over, Karen?
I think that would be great. Thanks.
Okay, and Senator Claxton. You're on mute, Senator.
I was just going to offer that most folks who get care out of state for their ALS have a local provider.
Yeah.
And as soon as that hits the problem list, then it's coded and becomes part of the electronic database that is readily accessible through HI Health InfoNet.
Yep. And I'm assuming, and Representative Perry, you're going to echo that?
I was, but I did have another question.
Yes, go right ahead.
The other question was, there was a request from Sarah Calder about ensuring that the information got shared with the national registry. And I was going to ask Sam if looks like that's a piece of that bill.
So the bill itself, I don't see language that specifically requires the department to share data with the National Registry. I don't see any problem with adding that. We may it may be helpful to ask Kim Hagan if there's some barrier that I'm not seeing there, but I don't see it in the language as drafted.
I see Kim has joined us. Kim, are you able to answer Sam's question about any issues with sharing with the national?
I don't see that there would be any issue, and we would do it with probably a bi-directional exchange MOU data sharing, that we could share data with them, and in return they could share data with us for Maine residents that were seen in other jurisdictions.
Great.
And the answer to the out-of-state providers is, my answer would be the same that Senator Claxton said, would be if they had a Maine primary care doctor that a Maine provider, even if they got treatment out of state, it would be flagged. And I'm assuming a lot of people would go to Massachusetts to get treatment. And if that was the case, then perhaps we could look into a regional exchange or a interjurisdiction exchange with Massachusetts.
Thank you. Sam, does that answer your questions?
It does, Representative.
Concerns?
Thank you.
Perfect. Yes, Representative Perry, then Representative Zaber.
Would it be possible to add wording to allow for the exchange with the CDC of that information? Sam, I think that's for you.
Yes, I can certainly add information that reflects Ms. Hagan's comments about the National Registry and the bidirectional MOU. Definitely.
Representative Zager.
Thank you, Madam Chair. I would like to make a motion ought to pass as amended to incorporate what Representative Perry and Ms. Hagan have brought up.
Second.
We have a motion and a second. Ought to pass as amended. Any further discussion from the committee? Seeing none, I would ask Karen to run the vote.
Thank you, Representative. Let me grab a pen. Okay, Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci.
Yes.
Senator Baldacci, yes. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan.
Yes.
Representative Madigan, yes. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
Yes.
Representative Connor, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Javner.
Yes.
Representative Javner, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
You're on mute.
The answer is still yes.
Senator Claxton, yes. Thank you.
Thank you. That is unanimous of all present, and that is our entire committee today. So with that, I would ask Sam if there is any additional work for us to conclude.
Today, Representative.
Yes, Senator.
Yes, I just wanted to point out that we've been warned about the purple papers coming from Luke. And since I don't think we'll get through the budget to the purple papers tomorrow, that maybe everybody could pick them up on Wednesday. Unless you want to print them out tonight and label them as purple, because that'll get confusing.
I really want to pick them up. Please.
Yep.
Yeah,
So
I would like
so
them
maybe
to be
Karen
able to
can have
pick
them
up on
available
Wednesday.
for us in the committee room.
That would be great. We really need to see purple.
Thank you.
I would entertain a motion to adjourn.
So moved.
All in favor? See you tomorrow. Thank you for your good work today.